appeal in the matter of Border Timbers Ltd and another and the Republic of Zimbabwe.
Well, Mr. Harris, if you really are going to be about an hour and a half, then I suggest we take a break when you finish your submissions.
Yes, so by way of update on that, my learned friend and I have exchanged overnight what we have come up with as a structure which we hope works for everyone, which is I will go from now to 11:45, then take the 5-minute mid-morning break. Mr. Mulan would then start at 11:50 and go through to 1. He would then continue his submissions from 2 till 3:45. Then we would have the break 3:45 to 3:50, and then I will reply 3:50 to around 4:15, which leaves us a few minutes to.
Which gives time for anything.
If there are any further points to wrap up, that's the plan.
Well, let's hope it works.
We'll do our best. My Lords, we concluded yesterday with my analysis of why we say it's abundantly clear from the text of Article 54 that there's a waiver of immunity and a submission to the jurisdiction of the English courts. Spain and Zimbabwe have no answer to the ordinary meaning, so they both try to avoid the text, but they mustn't be permitted to do that because it's a mandatory part of what I described to you yesterday, Article 31, the cardinal rule of treaty interpretation. Well, you'll recall that we touched yesterday really on the ordinary meaning of the language, and I told you that there were 2 other important aspects of that cardinal rule, which were context and object and purpose. So I'd like just to pick those up briefly, if I may. In terms of context, that's a mandatory element of the Article 31 rule, and it is defined in Article 31(2), which we looked at yesterday, as including the text of the treaty, which means that the terms are to be read in the light of the surrounding treaty provisions.
Where do we find that?
It's volume 7. Yeah. Tab 106.
Sorry, BCLT, sorry,
Sorry, yes.
101.
Sorry, 101, my Lords.
101, 106 is the ECT.
Yeah. And it's on page 3410. Sorry, 3411. Article 31.
Article 30.
Article 31.
2.
To be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. So that context is being read in the light of the surrounding treaty provisions and the treaty as a whole. And you can see in 2, the context for the purpose of interpretation shall comprise, in addition to the text, including its preamble annexes, various other matters. They're not important for our purposes. The point I want to emphasise is obviously that when we're looking at construing Article 54, we take that within the entire ICSID Convention, and in particular we take it in the context of that part of the ICSID Convention, which is Articles 53 to 55, and the regime they create. Now, my learned friend, Mr. Green, took you through those provisions yesterday or the day before, so I can be brief. And there are 2 real points of context that we make. First, Articles 53 to 55 create a scheme in which final awards are not subject to challenge or being reopened before domestic courts, supported by an effective regime of enforcement. And you will recall, my Lords, that in Mikula the Supreme Court had repeated regard to that ICSID Convention scheme, including the importance to that scheme of effective recognition and enforcement of awards. And the reference for that, for your note, is paragraph 104 of Mikula. And effective enforcement, we say, is served by Article 54(1 being a submission. Second point, within that scheme, only immunity from execution is preserved, not adjudicative immunity. And that makes sense because the obligation in Article 54.1 is inconsistent with maintaining adjudicative immunity, which we say also supports Article 54.1 constituting a submission. So those are the 2 points on context. Lord's object and purpose, again, that was addressed by my learned friend, Mr. Green, so I can take it relatively briefly. And again, there are 2 aspects I'd like to emphasise of it. First, it really is fundamental that the overarching objective of the ICSID Convention was to stimulate the flow of private investment into developing countries by removing an impediment to that flow, namely the risk investors perceive that they would not be adequately protected by the domestic courts of the host states where they were investing. And that mitigation of sovereign risk, which was recognised also in Mikula, was mentioned by my learned friend, Mr. Green. Secondly, that objective was to be achieved through granting investors access to a system of international arbitration that would produce binding awards not subject to control or interference of any national court. And that was the point I made yesterday about there being no seat of an ICSID arbitration, no supervisory court, supported by a regime that would ensure effective compliance. Now, Zimbabwe focuses only on the mechanism, the means of achieving the object and purpose. It says the object and purpose of the ICSID Convention is to create an arbitration mechanism. But that, in my submission, is not the right way to look at it. That's the means for achieving the object and purpose. The 2 points are in the object and purpose, we say, are evident from the passages in the preamble, which my learned friend Mr. Green took you through. And Mr. Green also took you to the High Court of Australia's acceptance of that object and purpose. For your note, it's paragraph 34 of the High Court of Australia's judgment. And again, we say the object and purpose is consistent with Article 54.1 constituting a submission agreement. Now, my Lord Justice Phillips had a question to my learned friend, Mr. Green, about the difference between mitigation of sovereign risk as the object and purpose, which we and ISL contend, and enforcement against investors as the object and purpose for which Spain contended. And it's an important distinction to keep in mind. There's a distinction between the object and purpose of the treaty, which is what Article 31 is looking at. You can see that just from the text of Article 31.1. The treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose, the treaties. What my learned friends seek to do is to try and focus on what they call the object and purpose of the provision. It's clear mitigation of sovereign risk is the object and purpose of the treaty. And the reason that my learned friends for the states parties seek to focus on the purpose of the provision is they say you look then to the Travaux, and that's where this point about being able to enforce against investors, cost awards against investors comes from. And they say, so you look at that as the purpose of the provision. But that is not an object and purpose that is relevant for the interpretative calculus under Article 31.
I apologize, my lord, that is not my case. I'm not sure.
So the overall conclusion we say, arising from Article 31, is that Article 54.1 is a submission agreement. That's the ordinary meaning of the terms of Article 54.1, read in light of in their context, in the light of the object and purpose of the ICSID Convention. Now, turning to the crux of the disagreement between ourselves and Spain and Zimbabwe, it appears that Spain and Zimbabwe both accept.
I'm sorry to take you out of your course.
Not at all.
Just going back to that point about what might or might not be in the Travo. I mean, it seems to me that in the preamble, the third recital, recognising while such disputes would usually be subject to national legal processes, international methods of settlement may be appropriate in certain cases, does rather sort of emphasise, it seems to me at least, that it's really in the cases of a claim by an investor against a state that this kicks in, because the state can always sue the investors in the national courts, and the investors wouldn't know, unless it's a state-to-state investment, as it were. But we're not looking at that. The state could sue the investor in its national courts, and there wouldn't be any resort, for example, to state immunity or any sort of supranational defence or anything of that kind.
Correct.
Where it really matters is where the investor, for example, hasn't been paid, or there's a dispute with the state where the investment is made, and they're sued in the national court of that state. At which point they raise all sorts of defences, including state immunity, which means that the investor doesn't get a cent at the end of the day, and that's exactly the sort of problem that this is focusing on, isn't it?
My lord, absolutely. Okay. Combined with the fact, of course, that if you've invested in a country and the country has expropriated your factory,
Yes.
you might not necessarily feel that you're likely in every jurisdiction to get justice seeking
From a national
reparation
court.
for that in the courts of that state.
Yeah. Right.
So, my lord, yes. So, my lord, it appears that both of the states accept that Article 54.1 is an agreement between all contracting states that they will each recognise and enforce awards. I say that because Council for Spain said that on day one, pages 118 and 119 of the transcript, and my learned friends of Zimbabwe, I think, say that in paragraph 3 of their supplemental skeleton. 13, sorry, of their supplemental skeleton. We say that is plainly a submission, that they say it is not. And the two key areas of disagreement are, one, whether the language is specific enough for such an agreement to amount to a submission, given the absence of reference to the word submission to the English courts or some other explicit language. And I addressed you on that yesterday, and I'm not going to repeat those points. The second part of it, which I will shortly address you on, is whether the submission is express or implied. As to that, we say it is express because it is simply the meaning which you get from the words when you complete the construction of Article 54.1. Now, my learned friend, Mr. Moulin, accepts that, in principle, when something is the necessary or inevitable consequence of the language of a clause, that's fine. That is not implied. That is express. That's paragraph 33 of the skeleton. And that is also what Mrs. Justice Diaz found when she was interpreting Article 54.1 as a waiver, because you'll recall, perhaps you won't, that Mrs. Justice Diaz found that Article 54.1 was a waiver at international law, but was not specific enough, in her view, to amount to a submission because it didn't specify the particular cause and the particular action. Spain and Zimbabwe take the position that at best any submission is implied, and that is predicated on their insistence on the need for either explicit language of submission in the case of Spain, or specificity as to court and claimant or proceeding. We say there are no such requirements, and there is no basis on which to find that the submission in Article 54.1 is not express. In any event, the arguments that are raised in this regard essentially rely on the speech of Lord Gough in Pinochet. And we say there are 3 points which show why that reliance is misconceived in this context. Firstly, as my lords will be aware, there are 7 speeches in Pinochet, only 2 of which address the question of express implied waiver. Lord Gough held that there was no waiver, and Lord Saville held that there was a waiver. My learned friend Mr. Ballot showed you some of Lord Gough's speech. Could I just give you the reference to Lord Saville's speech? I'm afraid I don't have time to take you through it this morning. That's volume 2, tab 17, pages 646 to 649. The key passage is sidelined on 648. Secondly, even in respect of Lord Gough's conclusion, the Torture Convention is a very different treaty from the ICSID Convention, concluded in and addressing very different circumstances. And as my Lord Justice Phillips identified on the first day of this hearing, in the case of the Torture Convention, in practice the maintenance of immunity is unlikely to cause problems in most cases and it wouldn't defeat the object and purpose of that convention, because people would be prosecuted in their home jurisdiction. That is, of course, not true, not at all true of the ICSID Convention, where the maintenance of immunity would defeat the scheme of the convention.
Are we not dealing with very different situations? Because here we're talking about civil submission to the jurisdiction, and that wasn't the issue of penal trials.
That's correct.
And I think one of the things I think was might need to be clarified. As I understand section 2, it is not in fact providing the test of waiver of state immunity. What it says is you're not immune if there's submission to the jurisdiction. So it's not saying you've got immunity but you waive it, it's saying you haven't got immunity if you submit. Now that seems to me simply to engage the English domestic test of have you submitted to the jurisdiction in writing, and nothing more.
Yes, well, I see that. I think the reason that the parties have spoken of waiver is obviously because when one is interpreting Article 54(1) as a matter of international law, what one is looking for there obviously is whether there's a waiver of immunity. But my Lord's quite right that
This is not a matter of international law, is it? This is a domestic statute which says if you submit to the jurisdiction of the English courts, you don't have immunity. That's not international law.
No.
And all one has to look at then is whether, as a matter of domestic law principles, Article 54 is a sufficient submission to the jurisdiction in writing. And unless nobody has shown us, I don't think there is, authority or otherwise rule that says that a submission to the jurisdiction must be express.
Yes, my Lord, I think.
Well, is that?
My Lord, the only caveat perhaps is, from recollection, in Pinochet, the point is made that Section 2 reflects customary international law. And that is perhaps why it is being looked at in that prism. But in a sense, we see them as sort of two sides of the same coin.
Yep.
The waiver angle faces it outwards internationally, and the submission angle is the domestic.
Yes. They may reflect it, but it's reflected by an English law concept, hasn't it?
It must be applied by this court.
Well, we're in territory, aren't we? And I'm puzzled about the same point. You look at the words prior written agreement, and what you would normally think is, well, looking at what is said to be the agreement here, Article 54. What is the correct construction of that agreement? Yes. And you wouldn't require it. It seems to me to use the word submission, for example. The question is, what does it mean on its true construction?
Yes.
Which is, at least in one sense, begins to shade into into the whole sort of, is there a real difference between express terms and implied terms? And it goes back to, you know, Lord Hoffman's type of analysis in Attorney General Belize. I mean, we may not need to get down that
I'm not
down
sure
that
what does.
road, because I think you say, well, look at Article 54. It is, as you said to us yesterday, each contracting state. So every contracting state, including the UK, is undertaking to every other contracting state that this is what it will do, and what that amounts to is a submission to the jurisdiction, and that's, you don't need to read anything else into it.
Correct. My lord, what we say is obviously that when you're, the process of interpreting, of construing Article 54(1) is something that you have to do using the international law approach, although as we discussed yesterday, it's not radically different from the approach that we're used to in these courts. Once you've identified what that construction is, you then apply Section 2 to that.
A classic formulation for submission to jurisdiction would be in a contract. The parties agree that the courts of England and Wales shall have exclusive jurisdiction, or shall have jurisdiction. You don't need the word submission. So to that extent, if the debate is, does it, to amount to submission of the jurisdiction, do you need to use the word submit, or do you need to have that sort of specificity? And I thought the answer is plainly not.
Well, that's our submission, obviously, and moving on from there, the reason I showed you NML yesterday, obviously, was because my own friends for Zimbabwe say it's got to specify, relying on Mrs. Justice Dias, that as well, that it has to specify a particular court and a particular proceeding. We say there's no basis for that, and Supreme Court
Well, the obvious
authority
answer to that is Article 17.2. Because if it recognises that it can be in a treaty is going to consist of mutual obligations between states, which will relate broadly to certain matters. It won't identify either of those matters, or indeed which particular state the proceedings would be in. So I don't see how you could construe 2.2 without reference to the guidance as to what could be a submission in 17.2.
Well, my Lord, we concur, and obviously that will
You
be
said
a point
that
of
And the
view.
chances of, if it is a treaty or convention, the chances of it having a provision that says you will submit to the jurisdiction of the English courts as opposed to any other court are pretty slim, because what you'd expect is something not unlike what you see in Article 54.
Indeed.
Wherever it is, if I'm sued in another contracting state in a case which falls within the remit, as it were, of the convention, I will
We say it's more than
accept that that's the jurisdiction of that court.
Indeed. We say it's more than specific enough. It's very clear. It's only the courts of contracting states that are going to be doing this, and that's the only places where the submission is, not non-contracting states, and it is only in respect of registration and enforcement of awards made under the ICSID Convention, not anything else. So we say that's enough. Lord, just finishing off on Pinochet, in case there were any doubt, the third point on it was that Lord Gough was obviously clearly troubled by the fact that immunity would cease to be available as soon as an allegation of torture is made, possibly unsupported by even prima facie evidence, and that it could potentially be motivated by political considerations. That's at page 219H and following of the report. Now, that does not apply, obviously, to the ICSID Convention, where immunity is given up only in respect of awards made by a tribunal after full legal process and with the additional safeguard of annulment. So again, it's a radically different position that is being looked at. So we say, for those reasons, that we must be right as to the proper interpretation of Article 54 as a matter of Article 31, and that then applying Section 2, that is clearly a submission. That being the case, and the the interpretation that you reach under Article 31 being clear, there is no need to have recourse to Article 32 and supplementary materials. And in any event, even if you were minded to look at them, you are only permitted to do it to confirm that meaning that you've arrived at under Article 31 and not to override it. As I said yesterday, that's critical because what you will hear is from our friends an attempt to rely on the travaux in order to determine the meaning, which is not permissible. But if you were minded to look at the travaux, I want to make clear we are in no way afraid of the travaux. The travaux confirm, in fact, that Article 54.1 is a submission agreement. We've given you, in footnote 42 of our supplemental skeleton, the reference to some of the statements of Chairman Roques, repeated in a number of places in the travaux, where he's specifying that in the same breath that immunity from execution is preserved, but that awards would be recognised and be enforced by being placed on the same footing as a final judgment of a national court. And what you have is, Learned Friends for Zimbabwe, they skip over the rule in Article 31 and misuse the travaux to determine the meaning of Article 54. And that interpretation is that Article 54 only operates to oblige a state to register an award either against an investor or where the state gives fresh submission for those recognition proceedings. That's at paragraphs 33, 2 and 34 of my learned friend's supplemental skeleton. Zimbabwe says that that is precisely what was contemplated in the travaux. Now, I'm not going to address you on Zimbabwe's various arguments on the travaux at this stage. I'll see how my learned friend develops them, and if I need to come back on them at all, I will do in reply. But we do say that it's a bit rich when you're a state which is not only openly refusing to comply with your Article 53 obligation to pay the award, but also even gave a specific undertaking to the ad hoc committee to get a stay of enforcement, that you would pay the award promptly if you lost the annulment. In those circumstances, to come before this court and seek to rely for interpretation purposes on the assumption that awards will all be complied with by states, we say that's a bit rich. It's not a primary interpretation point, obviously, but it's just something that's worth keeping in mind. And it does not end there, because what Zimbabwe does is it arrives at its interpretation through using the travaux, and then it says, well, we can now use the travaux to confirm our interpretation. And surprise, surprise, it goes back to them and confirms the interpretation that it's come to, entirely circular. Well, that's all I want to say about that aspect of interpretation, but I would like to pick up a few miscellaneous related points which have arisen.
Can I just, absolutely, before you do, can I just go back to this question of the interrelationship between Article 54 and Section 2.2? I think it's quite important. What you say, and I can see it, is that you have to interpret the treaty according to international law, because that is its governing law. But once you have done that, you then consider whether the resulting meaning is a submission as a matter of English law.
Correct.
Because that is the requirement of Section 2.2.
Absolutely.
And that then gives rise to English law principles of what constitutes a submission to the jurisdiction. Save that, it must be in writing.
Well, yes.
If that is not otherwise required.
Because that's what Section 2 says.
Yes.
Absolutely.
Thank you.
Lord, the first related point, just to make good, is you saw, my own friend Mr. Green took you to the provisions of the CPR which show the implementation.
Yeah.
And you'll recall the point about the rules having gone out of sync in 2014.
Yeah.
I just want to make the point briefly in the interest of time, but it is quite important. This isn't something that just happened in 2014. Immediately when the 66 Act came in, which was in 67,
Yes.
the Rules Committee introduced Rule 9 of Order 73 in 1968, Supreme Court rules. And I wasn't proposing to necessarily to take you through them, but I can. They're at volume 1, tab 3, if you want to look at them briefly. Just to make good the point that this has been the position since the beginning. And what the rule provided was that the procedure for the registration of ICSID awards would follow that for registration, for the recognition of foreign judgments, except for some carve-outs, notably that the procedure did not have to include notice to the state award debtor of the right to set aside the award, the time within which such time to set aside the award would apply, and that execution would be stayed pending the expiry of any set period. So you have a situation where immediate execution is available on registration. And that you can see at pages 49 and 50 of the bundle.
Yeah.
Under para 16 and sidelined. And if you want to see how that interacts, it interacts with the Supreme Court practice in 1967, which we've got in tab 1.
Tab 1, yeah.
And that is then at page 18. So Rule 7 of Order 71 concerning what a notice of registration to be served on the judgment debtor must include, and the excluded paragraphs 3C and D are the right to have to apply to have the registration order set aside and the period within which an application to set aside such order may be made. And the other reference that is in Rule 16 on page 50 at 2 is a reference to Rule 10 of Order 71, and that is in tab 1 at page 90. Over the page, the issue of execution. So paragraphs 1 and 2 there concern a bar on execution until the period for a set-aside challenge expires. Flipping back to page 50, you can see that Rule 10 is not one of the parts of Order 71 that's applicable to ICSID awards. So there's no bar.
Well, this is the exclusion of 10.1, and for that matter, 7.3d.
Yes.
Chime with the error that was made in the in rules in 2019. I think it was 2019.
2050.
No, because the rules until we left the European Union, the rules were all in sync. I think what happened, as I read it, is that with one of the withdrawal statutory instruments managed to get the numbering wrong by deleting subparagraph 1 of whichever rule it was. One became 2 and 2 became, sorry, the other way around, 2 became 1 and 3 became 2. And the one we're concerned with is what was 3 and is now 2.
Correct.
Which makes it clear that there isn't a time period. You don't get a sort of a period of time in which to contemplate whether or not you're going to apply to set it aside or something of that kind.
Right. Well,
that's what these rules are having the same effect. That's the only point I'm making.
That's what I wanted to show you, just that it was
exactly
the same from the start.
It's the same. It's essentially the same procedure from the outset.
Yes. Well, it's right to say, I think that we trawled through the whole process, and the change that occurred in the CPR when the renumbering happened, I think it was 2014 to 2015. That's when I think we've even got it in the bundle. I'm not sure I want to take time to show you, but it doesn't really matter whether it was 2014 or 2019.
No.
So, my Lord, what we say is that procedure in 1968 implemented confirms that Parliament intended to give effect to submission in Article 54.1. And the 1966 Act did so through the creation of a near automatic right to have the award registered, subject to providing an authenticated award, We say, as you know, and we'll come on to that, which must necessarily abrogate state immunity of common law at that time. Lord, second associated point, just to make briefly, is that although Zimbabwe tries to play down its significance, it is a striking feature of the international jurisprudence that every court that has been squarely faced with the issues that arise here and has heard full argument on them has concluded that the ICSID Convention contains a waiver of state immunity over adjudicative jurisdiction. Accordingly, if Zimbabwe's case were to be accepted, or Spain's case, that would make the UK an outlier on this important issue.
Just to be clear, the courts have given different reasons.
They have given different reasons, slightly different reasons, but
dealing with slightly different statutes.
well, yes and no. It's an important point because my learned friends rely very heavily on that. They say the statutory regime in different countries is different. But take, for example, the High Court of Australia. It is, and New Zealand as well, they're interpreting Article 54, and that's interpreted according to international law, which is the same in each jurisdiction.
And I can't remember the detail of the different decisions. At the moment you're on submission, how
Yes.
far do the different decisions rest on submission?
Well, what my focus, that's why in answer to my Lord Justice Phillips earlier, I was making the point that what matters in a sense when you're looking at the international plane is the meaning of Article 54.1 and whether that is a waiver of adjudicative immunity. That then in each jurisdiction may be translated differently.
I thought in Australia they were considering that issue against the identically worded statutory provision.
Yes. Now my learned friends say, well, they didn't have Section 9 equivalent because it doesn't work in Australia, but that seems to me a less relevant point. It's an identically worded submission provision.
As I understand it, the High Court of Australia decision on its face is entirely supports your arguments.
Correct.
As we got on this point.
Correct.
And it would require us to depart from their decision as to the application of our Section 2.2 to Article 54.
That would be my submission.
That's exactly what they decided.
A unanimous 7-member bench after hearing
The highest court in Australia,
the highest court in Australia.
highly regarded by all jurisdictions,
Indeed.
found this point exactly in essentially your client's favour.
And that was after 2 days of argument in a judgment where they considered very carefully the principles of waiver,
Including Lord Gough's decision.
including Lord
in
Goff's
Pinochet.
decision,
Yeah.
what the principle meant, how it should be applied, and applying the same international law provisions to the interpretation of Article 54. So, my Lord,
Well, it would be rather remarkable if we reached a different. Well, it certainly could, but it would be surprising if we reached a different conclusion.
my Lord, that was our submission below. It remains our submission here. Mrs. Justice Dias was less persuaded, but
She wasn't persuaded at all.
no. Well, she wasn't persuaded that it was a problem not to follow that or Mr. Justice Fraser's judgment, but her ladyship did note that obviously the High Court of Australia's analysis was persuasive, but where her ladyship, in our respectful submission, went astray was she was very influenced by my learned friend's submissions that in Australia they don't have the Section 9 exception, and so it's a slightly different domestic legislation basis.
I mean, the reality is that it's not just, as my Lord says, the High Court of Australia, which includes, amongst other judges, Mr. Justice Gleeson, who's, I think, the senior judge of all, but also it's an appeal from the full court of the federal court, which itself, the appeal to the High Court was dismissed, and the full court of the federal court included the previous Chief Justice also,
Correct.
who is really highly regarded. And the judge in the first instance had also found there was a waiver of immunity. So what one's really got is 11 Australian judges all pointing in one direction.
Lord, yes.
We're not supposed to say though, I understand that the statutory regime might be slightly different in that there's no equivalent of section 9. But although you might say that that would provide a different route by which an ICSID award could be enforced, notwithstanding what would otherwise be immunity, it doesn't actually in any way go to the question about whether there is submission. I'm not really sure how presence or absence of another route to recognition could in any way affect the interpretation of whether it's submission. How could it?
My Lord, it's the point that was made, I think, by my learned friend Mr. Balloch and was made by my learned friend Mr. Moulin below, the motivation, which, as was canvassed in argument with Mr. Balloch, we agree that the motivation is irrelevant. What matters is the analysis. I mean,
It doesn't change the interpretation. It changes the motivation of the court to reach a particular interpretation. That's a slightly tendentious distinction.
in my submission, my Lord, it's somewhat pejorative to suggest that the full 7-member bench of the High Court of Australia
Misinterpreted section 10 there, is it?
Yeah,
Deliberately misinterpreted section 10 because they wanted to make up for the fact they haven't got section 9, or equivalent to our section 9.
Yeah. Two final points, Lord. I should address you on the point which my learned friend successfully deployed below to cause Mrs. Justice Dias significant concern. That is my learned friend's argument that if Article 51 you find contains a submission, then so does Article 3 of the New York Convention. Lord, there are 4 points in response to that. First, nowhere in Articles 31 and 32 of the Vienna Convention is it permissible to interpret one treaty by reference to potential implications for a different treaty. The point doesn't arise. Secondly, in my submission, it is far from clear that on a proper interpretation of Article 3, it would be a waiver. Lord, perhaps we can just briefly turn up Article 3. That is in tab 97, which is in volume 7 of the authorities bundle. The very first tab. And we want page 3341. So tab 97, page 3341, Article 3. Each contracting state shall recognise arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon under the conditions laid down in the following articles. There shall not be imposed substantially more onerous conditions, higher fees, etc.
sorry, which page are you reading from?
3341, tab 97, 3341, Article 3.
Yeah, okay.
And it's the first sentence. And the words we emphasise are in accordance with the rules of procedure of the territory where the award is relied upon. Well, the reason we emphasise that is because as a matter of international law, state immunity is procedural. It's considered procedural. I know that might seem surprising from a domestic perspective, but this is an international treaty, the New York Convention. It has to be interpreted in accordance with international law. And the fact that under international law state immunity is procedural was recognised by the International Court of Justice in the Germany-Italy case, which you've got in the bundle, but it was also endorsed by Mr. Justice Henshaw in the Hulley Enterprises and Russia case.
Yeah.
which is in tab 49, volume 4. You might just briefly turn up. Volume 4, tab 49, and it's on page 1899. 1899, my lords. The learned judge, Justice Henshaw, says, you see in paragraph 234, I agree with Russia that the claimant's reference to our ICSID ad hoc committee decisions does not assist. As a matter of public international law, quote, the rules of state immunity are procedural in character and are confined to determining whether or not the courts of one state may exercise jurisdiction in respect of another state, and refers to the Germany and Italy case. So, my lord, we say that that reference in Article 3.2, in accordance with the rules of procedure of the territory in an international treaty, means that it's leaving questions of immunity to local law, which is completely different from, and that language isn't in Article 54 of the ICSID Convention. Now, rules, we're not asking you to interpret Article 3 of the New York Convention. You don't need to interpret it here, and you're not in a position really to do so properly because the materials aren't before you. My learned friends say in their skeleton that we conceded below that Article 3 is a waiver. That's not right. We said it may be, it may not be, it's not relevant. But whatever the case is, we maintain the position it isn't relevant. We actually say it is at least arguable that it isn't a waiver. But even if it were, my learned friends say this would upset a long-established consensus. But we say that can't be right. Long-established consensus, they say that there's no adjudicative immunity in relation to New York Convention awards. To our knowledge, that has never been argued or decided in this country. The only similar jurisdiction we're aware of where it has been argued is Australia, where it was actually decided last year by the federal court that it was a waiver of immunity. And there was an appeal heard on that case a couple of weeks ago. We don't have the judgment on that. So it's certainly right that some people in other jurisdictions have argued that it is a waiver, not by reference to Article 54, but generally.
Is that the decision of Mr. Justice Stewart that we've got in the bundle?
Yes, that may be right. It's tab 90, yes. Yes. Fourth, my lords, and just to make good this point, the position of Zimbabwe and which you can see at paragraph 21 of the judgment below caused Mrs. Justice Dyer's concern. We say is unduly alarmist because it is not clear that there would actually be any adverse consequences even if it were a waiver in Article 3. Think of it this way. If there isn't a waiver of immunity, the state can raise points challenging the jurisdiction of the tribunal under Section 9 of the Immunity Act. In a New York Convention case, if there is a waiver of immunity, the state still is able to raise just the same points on jurisdiction in the context of Section 103 of the Arbitration Act, the Article 5 New York Convention grounds. So the arguments can still be raised, it's just a question of timing, when.
Yeah.
So it's not the dramatic end of the world scenario that it's presented as. So that's what we say about the Article 3 of the New York Convention. We say it isn't a waiver, but you don't have to decide the point. Final point, before I turn to Section 9, I just want to address you shortly on a point that arose from Spain submissions. Mr. Ballot suggested, in response to a question from Lord Justice Newey on day 2, transcript page 22, lines 2 to 7, that where there is no arbitration agreement, there will be no valid award rendered pursuant to the Convention for the purpose of Article 54. And so the UK would not be in breach of its obligation in that article by refusing to recognise and enforce an award. So the suggestion seems to be that even if Article 54 is a submission to the jurisdiction for Section 2, such that the court has jurisdiction to decide whether to recognise or enforce. That only gets you halfway, because the court can only recognise or enforce, says Spain, if there's a valid arbitration agreement, and therefore an award rendered pursuant to the convention. And that means that investors would have to satisfy both sections 2 and section 9 in order to have an award registered. Now, my learned friend didn't go quite so far in terms, but that's the effect of his contention about awards rendered pursuant to the convention. That point was advanced by my learned friend Mr. Moulin below, and it was rightly rejected by Mrs. Justice Diaz, apologies, in paragraphs 76 to 78 of the judgment below. She concluded, I'll just quote it rather than take to it, accordingly, the words pursuant to this convention, in my judgment, mean no more or less than that the award has been rendered pursuant to the processes set out in the convention. If the annulment process has been pursued but failed, the award has been rendered pursuant to the convention, because the convention processes have been followed. That remains the case even if the application for annulment should have succeeded because the tribunal did not in fact have jurisdiction. It's not a question of treating the ICSID determination as binding for the purposes of state immunity. It is simply a question of whether the convention processes have been correctly observed without regard to the content of the decision which emerged at the end of those processes. Now, we don't understand that that contention is being advanced by Zimbabwe on appeal. It's not in their skeletons. But because of its impact potentially on the section 2 point in the way it arose in submissions, we just wanted to respond to that suggestion and flag it. So well, those are my primary submissions on section 2. With your leave, I will now turn to section 9, which is ground 3 in our response notice. My lords, the debate between the parties on this provision is in essence about whether there's a valid arbitration agreement that covers the claims that the border parties referred to arbitration. Zimbabwe says there is not. It says it disputes the substantive jurisdiction of the tribunal and says that the English court must rehear those arguments and any additional ones it comes up with de novo at this stage. Our position is that Zimbabwe is bound by the tribunal's ruling on jurisdiction and that it is not entitled to relitigate that question before the English courts. And we rely on two independent routes or ways of analysing that lead to that conclusion. The first is a statutory interpretation route, and the second is the issue of estoppel and related principles, including abuse of process. I'm going to start with the statutory interpretation approach, which is the primary way that we put our case. We rely on the principle of statutory interpretation by which domestic law is to be interpreted in conformity with international law. We put in the bundle a reference to Benyon on that, but I hope that's not a controversial submission. Accordingly, what we say is that in this case, the 1978 State Immunity Act must be construed against the backdrop of the UK's international obligations under the ICSID Convention. And we need to look briefly at three provisions. First, the three provisions of the ICSID Convention, and we can turn them up for ease in bundle 1 behind tab 2 on page 41.
Page
41, my lord. So first point is Article 53.1. The award shall be binding on the parties and shall not be subject to any appeal or to any other remedy except those provided in this convention. So Article 53.1 recognises that the only way in which you are allowed to challenge an ICSID award is through the internal annulment mechanism. And the corollary of that is that it is not permissible for the domestic courts of contracting states to engage in a review of the award or to revisit the tribunal's findings, including on jurisdiction. And that was confirmed by the Supreme Court in Mikula and the reference to that is at paragraph 68 of the judgment of the Supreme Court in Nicola. The next provision, my lord, is Article 54.1, which we've been looking at, and that first line, each contracting state shall recognise an award rendered pursuant to this convention as binding. As Mrs. Justice Dyers put it, this obligation to recognise awards, quotes, applies to the entirety of the award and involves acceptance of both the binding character of the award and its preclusive effects as regard, for example, res judicata and issue estoppel. That's paragraph 35 of the judgment below.
Yeah.
So there's an obligation to treat the award as binding and as having preclusive effect. And that obligation extends to the entirety of the award, including the decision on jurisdiction. Lord, what do those obligations mean for the construction of Section 9 of the 78 Act? Well, as I mentioned earlier, it's to be presumed that Parliament intended that the UK should comply with its international obligations. And that so far as possible, domestic legislation must be construed in a way that's compatible with such obligations. In the case of Section 9, the way to give effect to that approach in our submission is to read Section 9 in such a way that a finding of jurisdiction in an ICSID award is treated as conclusive evidence that there is an arbitration agreement which covers the relevant dispute. Any other reading of Section 9 would, in our submission, place the UK in breach of its obligations under the Convention, which is the very result that the Court must presume Parliament intended to avoid. In particular, if the courts of this jurisdiction did not treat an ICSID award as conclusive evidence of a valid arbitration agreement, such that a state can have a de novo rehearing of that question before the English courts, that would place the UK in direct breach of its obligations to refrain from reviewing an ICSID award and second-guessing the tribunal's jurisdiction, and its obligations to recognise an award, including the decision on jurisdiction, and give it preclusive effect. So for that reason, we submit that the award is conclusive of the question that arises under Section 9 as to whether there was a valid and applicable arbitration agreement, and Zimbabwe isn't entitled to a de novo rehearing of that. Now, Zimbabwe says that we're wrong about that. Zimbabwe says that we conflate the distinction that they see between avenues for challenging an award and state immunity. We say that takes Zimbabwe nowhere. It doesn't answer our point that the ICSID Convention requires the UK to recognise an ICSID award, which means treating the award as conclusive on every matter it decides. It simply can't be that you can then say, well, there's another piece of legislation which allows us, which is domestic legislation, which allows us to completely contradict the international law obligation we've undertaken in the Convention. Secondly, Zimbabwe says that there's no basis for our interpretation in the language of Section 9. Again, we say that's misconceived. Section 9 simply requires a valid and applicable arbitration agreement. It is silent as to how the court is to satisfy itself of that and as to what evidence is required for that purpose. Those are matters left to the court. So in my submission, there's nothing, therefore, to displace the presumption that Parliament intended the UK to comply with its obligations under the Convention. Thirdly, Zimbabwe says our interpretation involves the logical fallacy, they call it, of assuming that is which is required to be proven, and that there's no room for an interpretation of Section 9 which deems its requirements to be satisfied. But we're not inviting the court to assume that there's an arbitration agreement that satisfies Section 9. Instead, we're saying that the court should, indeed must, recognise as binding the tribunal's decision that there's a valid and binding arbitration agreement. That is no different in principle from recognising that Section 9 can be satisfied without independent inquiry by the English court through an issue estoppel arising from, for example, a foreign court decision. And we've shown you in our skeleton some cases which make point clear that that can be done. Paragraph 63 of our skeleton. Zimbabwe makes a further point that our statutory construction argument relies on us being correct about our interpretation of Article 54 of the Convention. I don't currently completely understand how that point is being made, so I will let my learned friend develop it and see if there's anything I need to say in reply to that. But that is what we say on our primary case. So I then turn to our alternative way of looking at it, which is through the prism of issue estoppel. There are 3 points which we understand in relation to issue estoppel are common ground. First, it doesn't appear to be in dispute, that point I just made, that Section 9 can in principle be established through an issue estoppel without the court independently determining the existence and scope of the arbitration agreement. That's, as I said, para 63 of our skeleton and para 98 of my learned friend's supplementary skeleton. And that was recently confirmed in the Hulley and Russia decision of Mrs. Justice Cockrell, which is at tab 5 of the authority, sorry, volume 5, tab 59 of the authorities bundle. So in summary, Lords, Mrs. Justice Cockrell concluded that the requirements of Section 9 can be satisfied by an issue estoppel, which in that case arose from a judgment of the Supervisory Court. It's a New York Convention award for enforcement. And her ladyship rejected Russia's contention that an independent assessment of the tribunal's jurisdiction by the English court is required in every case. It was the entire sort of core question in this judgment, so there are a number of paragraphs that deal with it from, I think, paragraph 19 to 55, but the key is from paragraph 30 onwards on page 2362. Starting point, no clear authority on this point either way. There's no case in which an issue estoppel has been found against a foreign state via a foreign judgment, but equally no case where it's been said that such an estoppel could not arise. The balance of authority tends to favour the claimants, in that there are 2 cases which implicitly recognise the possibility of issue estoppel against the state. They refer, in that regard, first to Dalla, and then at 35 to Diag Human and the Czech Republic, the judgment of Mr. Justice Eder. Then over the page at 38, there is a reference to the judgment of, I believe that's the judgment of my lord the Chancellor in Zongshan and Nigeria.
Yeah, that's the one where we,
But just saying that it does suggest that it supports the proposition advanced to the claimant. There's nothing in the 1978 Act which indicates that an estoppel is impermissible. Then the ladyship at 39 looks at the rules and is comforted in that. And then at 48, over the page at 2365, after analysing section 31 of the CJJA, because this was about a Dutch court judgment, follows I conclude there's no reason why, if the relevant hurdles are clear, there cannot be an issue of estoppel arising out of a foreign judgment against the state, just as there can be against an ordinary company or individual. And she applies it. We've also referred in our skeleton to Svenska in the Court of Appeal and the Singapore International Court of Appeal case in which Lord Mance played a leading role in Republic of India and Deutsche Telekom, which reflects the same proposition. in relation to a provision in almost identical terms to Section 9 in Singapore that is satisfied by issue. Secondly, so the requirements for establishing an issue estoppel are also apparently common ground, and that's the good challenger decision, which I'm sure my lords are familiar with, the four elements of judgment given by a foreign court of competent jurisdiction. The first one. Second, the judgment must be final and conclusive on the merits. Third, there must be an identity of parties. And fourth, there must be an identity of subject matter. The third point of, it's also, whilst expressed as by reference to a foreign judgment, the principles are of general application as Zimbabwe accepts at para 95 of its supplemental skeleton. The third point of common ground appears to be that the tribunal's ruling on jurisdiction in the award satisfies the second, third and fourth elements of the good challenger. The point of dispute seems to be on the first aspect, i.e. whether the tribunal was competent conclusively to determine its own jurisdiction. And it's to that question which I will focus my submissions. So as we understand it, Zimbabwe's position is that in order for that jurisdictional limb, one, to be satisfied, there must be an arbitration agreement. So Zimbabwe says, therefore, that before an issue estoppel can arise, we must prove, independently of the award, that there was a valid arbitration agreement. And for that reason, Zimbabwe says we can't short-circuit Section 9 with an issue estoppel, and there has to be a de novo rehearing. We say that the arbitration agreement is not the only source of the tribunal's authority to rule on its jurisdiction. And that's something that's quite unusual about ICSID. The tribunal independently has authority to rule on its jurisdiction by reason of Zimbabwe's undisputed agreement to the ICSID Convention and agreement to the BIT. Zimbabwe doesn't dispute it's a party to both of those treaties. So we say that by signing up to the ICSID Convention, Zimbabwe has agreed to a regime which makes the ICSID organs, by which I mean the tribunal and the ad hoc committee, the final arbiters of jurisdiction. And by signing up to the bilateral investment treaty, Zimbabwe has consented to that regime being applied to claims brought under the BIT, meaning that Zimbabwe has agreed that the ICSID organs will be the final arbiters of jurisdiction in relation to such claims. So we say the combination of that means that Zimbabwe has agreed to it. I'd like to just show you, if I may briefly, an authority which explains what it means to be a court or tribunal of competent jurisdiction for issue estoppel purposes. And that is Vizcaya Partners and Picard, a 2016 decision of the Privy Council. That's in Authorities Bundle Volume 3 at tab 38. This was a decision of the Privy Council in which Lord Collins delivered the judgment of the board. It's a case about enforcement of a foreign judgment rather than issue estoppel, but the jurisdictional limb of the test is the same in both contexts. If we can pick it up at paragraph 3 of the judgment on 1266, my lords, we see that what Lord Collins is considering there is the circumstances in which a foreign court is considered to have jurisdiction by reason of a prior submission. And he quotes the passage from Dicey, which I'd just invite your lordships to read. Now, in relation to that fourth case, we can pick that up then a little later on at paragraph 56 on page 1278. relevant principles governing the fourth case are described by Lord Collins. The first two propositions you see in 56 are whether the judgment, the question is whether the judgment debtor agreed to submit to the jurisdiction of the foreign court. Second, the agreement does not have to be contractual in nature. The real question is whether the judgment debtor consented in advance to the jurisdiction of the foreign court. And there's a quotation from Lord Justice Goff, as he then was. Whether it's expressed willingness or consented to or acknowledged that it would accept the jurisdiction.
I think that's actually the previous Lord Justice
Sorry,
Goff.
indeed. Lord, you're quite right. So the touchstone is the consent of the party said to be estopped. We say the position is no different in the arbitration context. Normally, we quite accept, normally the consent will be found in the arbitration agreement itself. But the arbitration agreement is not the only possibility. And as I've touched on already, it is not what we rely on to found the issue estoppel here. Consent can obviously be given outside of the arbitration agreement, and as with a foreign court, it can be given unilaterally and in a non-contractual form. Now, having identified some of the legal principles, let me address you on the parties' positions on this jurisdictional limit in a little more detail. Zimbabwe's position on this is put in various ways and deploying various epithets, inherent circularity and bootstrapping being prime among them. But all of those points boil down to the same thing. Zimbabwe says if there was no valid arbitration agreement, then the tribunal had no jurisdiction, and it couldn't change that fact by issuing an award which wrongly found that it did have jurisdiction. A relatively classic statement of the law in a New York Convention case. So you can see that what Zimbabwe is focusing on here is whether the tribunal had substantive jurisdiction, i.e. whether it was competent to determine the substantive claims under the BIT because there was a valid arbitration agreement that covered those claims. You can see that inter alia from paragraph 80 of Malone and Friends' supplemental skeleton. But that misses the point in my respectful submission. Zimbabwe is focusing on the wrong thing. The issue here is whether the tribunal's ruling on the validity and applicability of the arbitration agreement is res judicata. That does not depend on whether the tribunal had jurisdiction in the sense used by Zimbabwe, competence to determine the substantive claims in the arbitration. Instead, it depends on whether the tribunal had jurisdiction in a different sense, namely whether it was competent to rule on its own jurisdiction and to do so conclusively. And they are different inquiries. Whether the tribunal had substantive jurisdiction depends on whether the offer of ICSID arbitration in the BIT was validly taken up by the border parties, and therefore whether there was a valid substantive arbitration agreement that covers the claims under the BIT. That was a matter in dispute in the arbitration, and we understand that Zimbabwe wishes it to remain in dispute. In contrast, the tribunal's competence to rule on its own jurisdiction stems from Zimbabwe's consent to the ICSID Convention and to the BIT, both instruments which I said earlier Zimbabwe accepts it's a party to. By signing up to the ICSID Convention, Zimbabwe consented to a regime where the ICSID Tribunal and any ad hoc committee are the final arbiters of jurisdiction. By signing up to the BIT, Zimbabwe consented to that regime being applied to claims brought or purportedly brought under the BIT. So Zimbabwe agreed in simple terms that anybody bringing a claim under the BIT, those claims have to be referred to ICSID, because it's the only option under the BIT, and that they are then to be determined whether they're good or not by that ICSID tribunal, whether they fall within the jurisdictional parameters by that ICSID tribunal, within the convention rules. We say Zimbabwe's failure to appreciate this crucial distinction between substantive jurisdiction and jurisdiction to determine its own jurisdiction means that almost everything it submits about issue estoppel is misdirected and doesn't engage with the right question. Now, can I just make good my point about why the ICSID Convention works in that way? We'll start with the ICSID Convention, which, as we know, Zimbabwe accepts as binding on it. That's again, Volume 1, Tab 2. We turn to page 38. You have Article 41.1 of the Convention, which says that the tribunal shall be the judge of its own competence.
Do you have to go back first to Article 25?
Oh, yes,
Because that deals with the jurisdiction.
indeed.
So you were going to go, sorry, maybe anticipating.
No, that deals with the jurisdiction of the centre extending to any legal dispute arising out of investment between a contracting state and a national of another contracting state. But it doesn't, the way it works, obviously, is that you need a BIT to give you access to ICSID.
Yes. And once you have, then isn't Article 25 the foundation of the jurisdiction?
Correct, that's right.
The reason I ask is because we haven't looked at Article 25 before.
Yes.
Is your concern the reference to which the parties to the dispute consent in writing to submit to the centre?
Sorry, I'm afraid I didn't hear that. Mr. Tompkins was saying something.
In Article 25.1,
Yes.
we get at the end of that first sentence which the parties to the dispute consent in writing to submit to the centre. Is that why you have reservations about this being the answer in itself?
Yes, well that's simply a reference to the BIT.
Yes.
Yeah, where's the BIT? Can we just have a quick
The
look?
BIT, Lord, I was going to take you to that next.
Yeah.
That is in the supplementary bundle, which is one of the small bundles, in our case, tab 3. Oh, sorry. Haven't got the actual BIT. We've got the relevant clause in the The relevant clause is in the award.
Let's have a look.
So that is page 43, Lords.
In the core.
No, it's the supplemental bundle it's called. It's another small bundle in our appeal. The core bundle and the supplemental bundle.
Paragraph 43.
Page 43, the tribunal, this is the award in our case, and the tribunal sets out Article 10 of the Switzerland-Zimbabwe BIT. And it's 10.2. If the consultations in 10.1 don't result in a solution within 6 months, and if the investor concerned gives written consent, the dispute shall be submitted to arbitration of the International Centre for the Settlement of Investment Disputes, i.e. ICSID.
I'm sorry, Mr. Harris, I got behind.
Apologies,
looking at
it's
now?
in the supplemental bundle,
Yes.
tab 3,
Tab 3.
page 43. It's in the award, the relevant. Right, is that the Spain supplemental bundle?
Yes.
Yeah, no, we have our own
Oh,
supplemental
I'm
bundle.
sorry.
No, I know, it's forgive me, it's, I don't know whether yours looks like mine, but mine's a small one.
It's not quite so small.
Oh,
You see,
right.
the point being that the Article 10.2 of the Swiss BIT says if the investor concerns gives written consent, and the tribunal found at page paragraph 196 at the border claimants that express a consent to submit by the request to arbitration,
which is absolutely vanilla way it works in BIT.
Precisely.
So that
So
tends to
Article 10 is satisfied, and on that basis, what you say, going back to Article 25, and the point my Lord Justice Newey asked you would say, which the parties to the dispute consent in writing submit to the centre. So
Yeah.
it's a combination of the Article 10 of the bit and the request for arbitration.
correct.
That's taken together. They comprise a consent in writing by both parties.
That's entirely correct. Oh, yes.
Right, just to be clear, as I understand it, Article 41, the thing that gives the tribunal the jurisdiction to determine its own competence
Yes.
is the combination of the bit Article 25 and, to the extent there is one, a request for arbitration.
So that goes to whether there's an arbitration agreement, and the question is whether the arbitration agreement is final. So the arbitration agreement is formed by Article 10 of the BIT and the investor's acceptance by the request for arbitration, notice of arbitration, whatever it may be, starting the arbitration. Article 25 is simply meaning that you've got to have that for ICSID to be engaged, but it's not. There's no judgment of validity in Article 25(1). That's the point I just want to be clear on. That is Article 41(1), the tribunal that determines whether things have been complied with.
Well, it determines, amongst other things, presumably whether it has jurisdiction in respect to the dispute that's been referred to.
Yes.
And the intention of 41(1) is that that's for the tribunal and not for anybody else.
That's our case. Because we would say that's what the treaty says.
Yeah.
So particularly where that is a self-standing regime, which I don't think is sensibly in dispute, and you have exclusive remedies in Articles 50 to 52 of the Convention, which you looked at, Mr. Green, the interpretation, revision, and then annulment,
Yeah.
including annulment under Article 52(1)(b), which is
manifestly exceeded his powers.
the jurisdiction heading. There is simply no scope for any form of
So
further
if the
review of
annulment
the
committee says no, the tribunal has not manifestly exceeded its powers, and the dispute which is determined in its award was within the jurisdiction which it was given, which it had, that's conclusive, and that's an end of it.
Correct. And then you've got obviously Article 53, which confirms that by saying the award should be binding on the parties and not subject to any appeal or other remedy except those provided for in this convention.
Yeah.
And that's supported by, again, the Supreme Court in Mikola, paragraph 68 and 78, which expressly say that the court cannot look at these points again, and makes the point two ways. It may not re-examine anything within the award, and also it certainly cannot look at matters which overlap. You may recall that language in paragraph 68 and 78 in Mikola, which overlap with the grounds for challenge under the convention, which plainly a jurisdictional review does. So Zimbabwe agreed to a BIT offering certain protection to putative investors. It gave those investors the opportunity to go to ICSID if they had a claim under the BIT, and it clothed, by its agreement to the BIT and the convention, the ICSID tribunal with the authority to determine whether it had jurisdiction over those claims.
Yeah.
And to do so finally. That's why we say that Zimbabwe has accepted not only that the tribunal would be competent to rule on its own jurisdiction, but that its ruling would be final unless the award is annulled. That is not circular or bootstrapping because of the very different position. You don't, in ordinary arbitration context, have a position where there is a separate agreement by the state to two binding international law instruments which give a tribunal its power. Usually, the tribunal's power to rule on its jurisdiction arises under the arbitration agreement itself.
Yeah.
That's why ICSID is just a different conceptual beast. So we're not relying, just to be very clear, we're not relying on the award to show the tribunal was competent to rule on its own jurisdiction. We don't rely.
We're not in the territory of a normal New York Convention or Arbitration Act situation where at least as the Act currently stands, and since it hasn't yet been amended because there's a general election, a party can actually dispute the jurisdiction of the arbitrators and then take the point again before the court.
Well, yes.
And under this regime, you've got to do it before the arbitrators, before the tribunal. And if the tribunal rules against you, that's the beginning and the end of it.
There's no section
So
67.
there's no section 67 et al.
Not at all. Exactly.
Applicable to ICSID awards.
That would be entirely inconsistent with the requirements of the UK's obligations under the
Yeah.
ICSID Convention.
Zimbabwe's argument effectively that in the context of state immunity, Section 9 effectively operates like Section 67.
Yes. And it's somehow an exception to the rules of the ICSID Convention. So you can reconsider by dint of the domestic statute, you can reconsider matters which you've undertaken under the ICSID Convention that you can't.
I suppose the counter, when you say one was taken to assume that the UK was aware of its international obligations in passing the 78 Act, I suppose it could be said that in enacting Section 9, the UK did not carve out or expressly recognise that it was not necessary to show binding arbitration agreement in order to avoid state immunity under Section 9.
Correct. We say, because of the way that the convention works, it's just such it's a totally different world that we're in, because it has been that the state has agreed whatever its dispute about the substantive jurisdiction of the tribunal, it has agreed in two independent international instruments that is for the tribunal to decide, and for the tribunal to decide finally, subject only to potential annulment. Lords, on this point, realising that I have 15 minutes left, can I just pick up very briefly at 2 points? I just should shortly address you on the Tatneft and Ukraine decision, which
Yes.
I anticipate my learned friends will rely on, and certainly Mrs. Justice Dias referenced. That decision, it's in volume 3 of the authorities bundle at tab 43. I'm not sure we need to turn it up at any length, but it was a case in which, it's right at the back, Tatneft was seeking to enforce a New York Convention award against Ukraine. It's a New York Convention case. And the argument in essence was, can you argue things on a Section 9 challenge, jurisdictional points you didn't take before the tribunal? And Mr. Foxton at the time was contending that, by analogy, the Section 73 of the Arbitration Act waiver rule would apply to prevent you. So in the same way that under Article 67, you're not allowed, Section 67, you're not usually allowed to run new points on jurisdiction where you didn't run them in the arbitration.
Yeah.
The same would apply under Section 9. And in essence, Mr. Justice Butcher's decision is that's not applicable under Section 9 because on a proper interpretation of Section 9, it's a separate regime. And there's no, so what he is saying, and the relevant paragraph is paragraph 35 on page 16 to 2. That's the point that's relied upon by Malone and Friends. But that paragraph, what he's saying, and all the learned judge is saying, is that there is no automatic waiver for the purposes of Section 9 if a state fails to raise a jurisdictional point before the tribunal. In my submission, it doesn't address the different question which arises here as to whether a tribunal's decision on jurisdiction gives rise to an issue estoppel that precludes Zimbabwe from advancing a contrary argument. Doesn't decide that question because there's no point about issue estoppel raised in that case, unsurprisingly, given it was a New York Convention case. And it's questionable even whether the decision about waiver could hold good in an ICSID context for the reasons that were discussed in an exchange between the learned friend Mr. Green and my Lord the Chancellor in relation to Mikula, given that the ICSID Convention prevents the award being reopened, not just based on matters that were in fact argued, but also on matters that could have been argued, that fall within Articles 50 and 52. This is Justice Dyer's.
The one short answer to paragraph 35. This is Justice Butcher's judgment, since he wasn't considering, as it were, a parallel self-contained regime, which is like ICSID. He was considering whether there was anything in the State Immunity Act itself, which was parallel with the sections 67 to 73 of the Arbitration Act, and a fairly obvious conclusion was no. That non-constat, if you've got the whole of the ICSID and related regime.
Well, that's right. Well, we have mentioned in our skeleton argument that another way of viewing this, in addition to issue estoppel, is abuse of process, and we've given the reference there, particularly to the Zongshan case that I mentioned earlier. In view of the time, I have to now move to section 23, our section 23 argument, subject to anything further on this point.
Okay, let's say, I mean, one answer to the problems with section 9 and its express wording is, of course, if you're right on section 2 and there is submission, then we don't even get, none of this arises.
Quite right.
So you might have to look at section 9 through that lens. But obviously, if one's looking at it through that lens, you've already succeeded.
Yes. Well, we say that, as my Lord knows, that actually as I'm going on to section 23, we're in a different situation where the State Immunity Act just doesn't apply at all. But if it does, there's a waiver, and even if there isn't a waiver, there is an arbitration waiver, effectively, which is what section 9 is, because section 9 is, in some sense, is a sort of species of section 2 in relation to arbitration. So, my Lord, I'll take section 23 very quickly. It really has two parts, our section 23 argument. The first part has been admirably addressed by Mr. Green, so I don't need to take it very long. The first part is that the 1966 Act must have abrogated adjudicative immunity, because if it didn't, Parliament had enacted a dead letter. It would not, if it didn't abrogate adjudicative immunity, the 1966 Act would not have been usable to register and enforce awards other than what Malone and Friends say, it would be fine because you could use it to enforce costs awards against investors, or they say where the state consented. So in that parallel universe, which you might think is a rather odd thing for a state that's refusing to comply with an award to nonetheless consent to it being registered and enforced against it. So we say that's not a sensible interpretation. So there must have been an abrogation for that reason. And we've developed it a little bit in more detail.
Well, the whole point of going back to the preamble to the convention is at least one of the main points that's being made was to ensure that people had remedies against the state through the convention that weren't dependent upon the state saying, okay, well, if you sue me, I'll submit to the jurisdiction.
Yeah, because if that were the case, it would be writ in water effectively. Well, well, it's right to say that there's no dispute on this side that the idea was that Article 54 was to work both ways.
Yeah, sure.
What Malone and Friends seek to say is that it was only focused one way against investors. We say it was intended to work equally for both. The 66 Act wouldn't do that if it didn't abrogate immunity. Now, the second aspect to our submission is the 1978 Act didn't change that. Just conceptually stepping back, it would be a very odd thing when making a new statute, the purpose of which in general was to relax the rules of state immunity, to move towards restrictive immunity.
Yeah.
Parliament decided to make it harder in relation to ICSID awards. So we say that's in principle a difficult matter. And we say the way that is to be viewed, my other friend has his position on harmonious interpretation, and we don't dissent from that. We say another way that you can look at it is through Article 23.3. We say the words of Article 23.3 are wide enough to encompass, sorry, Section 23.3. Apologies, there are too many articles and sections. The words of Section 23 I completely accept, but all the Chancellor's point to learn a friend that it's not necessarily the instinctive reaction one has reading the words, but they are wide enough in my submission. Subject to subsection 4 below, parts 1, and this is bundle 1, tab 4, page 63. They do not apply, parts 1 and 2 of the Act do not apply to proceedings in respect of matters that occurred before the date of the coming into force of this Act. So we say the words are wide enough to encompass claims brought pursuant to previous legislation. And Malone and Friends sort of case in response to that, they say, well, it would invalidate all sorts of it would take all sorts of earlier legislation outside the scope of the State Immunity Act. Well, we say that's not right. We don't say that every piece of earlier legislation is going to be a relevant matter. It just makes particular sense in respect to the 1966 Act for claims under it to be the relevant matter, because that deals with that there is a real need for immunity there to be relevant. So, for example, Malone and Friends give the example of the Law Reform Miscellaneous Provisions Act 1934, which allows the estate of a deceased person to maintain tort claims after death. They say that would be also affected by this. Well, we say it wouldn't, because for the purposes of Section 23.3, the fact that a claim was founded on that Act wouldn't be the relevant matter. So the claims would not fall outside the 1978 Act. And that makes sense because the 1934 Act has nothing really to do with state immunity. So there's no rationale for excluding it entirely from the 1978 Act, contrary 1966 Act.
So you're reading matters that occurred as being the 1966 Act.
Lord, yes, we say that the words in respect of matters that occurred before the date of the coming into force of this Act are of wide import and are capable of embracing claims to register an ICSID award. that it makes sense.
Just to drill down into it, the matters that occurred, that's the 1966.
Yeah.
And that's all.
Yeah.
Because there's no other matter that occurred.
No.
So this subsection is referring to another Act of Parliament as a matter that occurred.
Good. It's not a very easy argument, Mr. Harris.
Well,
You've got other arguments.
I accept my lord made that point the other day. Can I just make one final observation on this though? If you're with me on stage 1 of the argument, which is the statutory abrogation in 1966, but not stage 2, section 23(3) analysis, that still supports our case in another way. If in 1966 Parliament abrogated state immunity in respect of proceedings to register an ICSID award, it would be most unusual for Parliament to have then enacted a more onerous regime in 1978 that would make it more difficult to enforce an ICSID award, which is my learned friend's contention. We would say that would strongly suggest that the exceptions in Section 2 and Section 9 of the State Immunity Act must be interpreted or applied in a way which ensures that a state that is that has an ICSID award made against it cannot prevent registration by claiming immunity.
That's going back to your previous.
Well, that's back to your point about Section 2.
Well, it is. It's saying, if you're with me that there must have been an abrogation, that would influence how you look at Section 2 and Section 9, rather than my previous arguments, which were just looking at them per se.
Yeah.
Lord, my last point is this. You have seen Zimbabwe's ground 6. It has, it's inviting you, even if you're against it on immunity, not to dismiss its set-aside application, but to remit it to the commercial court, because it says it has one of those exceptional points that the Supreme Court mentioned in Nicola. It is unclear precisely what the point is, but it seems to be an untrue allegation that my clients remain in occupation of some of the land that was found to have been expropriated. That allegation is not correct. We have our evidence on the record, the statement of Mr. Mills, which rebuts the statement of Ms. Chimbaru from Zimbabwe on that point. But I'm not asking the court to decide that factual issue, obviously. We say even if it were true, it is a million miles away from the exceptional circumstances envisaged by the Supreme Court in Nicola. And it would, in fact, be a plain and simple attempt to appeal the tribunal's determination. Lords, so we say it's just another delay tactic, and we would therefore invite you not to accede to that. What you had in the award, which may be what is being relied on, the award is slightly unusual in that the tribunal, perhaps trying to be particularly generous to Zimbabwe, made an award of $125 million for the expropriation of the land, but it gave Zimbabwe a 90-day period in which, if it restituted the title to the land to my clients, it would only have to pay $29 million, the lower amount. Now, there's no dispute that Zimbabwe did not give the land back, or the title to the land back to my clients. That's not even claimed. Ms. Chimbaru doesn't even say that. And so we say the argument just doesn't get off the ground. There's certainly no basis for suggesting that it is the sort of fraud case which arises in the contemplation of the Supreme Court. The only other point Zimbabwe makes in response is if Zimbabwe says we shouldn't be allowed to run this point because we accepted in the CMC order right at the outset of this case that they might be able to raise further non-immunity defences. Well, we say that that's a bad point. All Zimbabwe's reservations said at that time that it was that if it lost on immunity, it reserved the right to take any further steps open to it, including resisting immunity on non-immunity grounds. We didn't object to that reservation being included in order for obvious reasons, but that doesn't mean we were consenting in advance to the remission that Zimbabwe seeks, or that we were agreeing there should be a remission in all circumstances, even when there's no good reason for it being given. My Lords, apologies for the slight canter towards the end, but unless there are any further points taken this issue with, those are my submissions.
Thank you very much, Mr. Harris. We'll take a break.
Court rise if able.
Yes. Chancellor takes you off. Yeah. I've also got there. They're going to show you that.
court ready?
Well, sorry.
Court rise if able.
Your lordships, I come last to the party,
Yes.
and my lords, I feel my participation has been billed somewhat unfairly by all my learned friends. I do not think that over the past 3 days, my name has been uttered otherwise than in combination with the words, "will take you through the travaux of the convention." This is somewhat mystifying, my lords, because our case is not based on the travaux, as my learned friend Mr. Harris has submitted. It is based fairly and squarely on the text of Article 54.1 of the ICSID Convention interpreted in good faith and in its context and with regard to its object and purpose. That meaning is clear, we respectfully submit, once basic elements which do not appear to have yet been brought to the court's attention are taken into account. This includes, my lords, the very important point that Article 54 operates on two separate legal planes. It creates, at the international law level, an obligation on states to create an enforcement mechanism at the domestic law level. That is entirely different from a commercial contract operating solely on the domestic law level. But we shall come to that. I'm even more mystified, my lords, as to why my learned friend, even though he's saying, well, but we can take you to the travaux if you want, in effect, compared to what was done at first instance, why my learned friend is now running so scared of the travaux. That wasn't the case below, as I just said, and I can only conclude that the border claimants have finally realized how inconsistent their case is with the travaux of the convention. The use of travaux, my lords, is perfectly commonplace in any exercise of interpretation of an international convention. And with respect to this specific convention, the ICSID Convention, commentators, including Professor Schroyer, have made extensive use of them. Given that my learned friend Mr. Green has referred to his time at DG4, I hope I can be excused for noting that I have myself chaired the work on the only other international convention in the field of investment arbitration, and that is the Mauritius Convention on Transparency in Treaty-Based Investment Arbitration of 2015, as chairman of UNCITRAL, the United Nations Commission on International Trade Law. As such, my lords, I'm well aware of the pitfalls of travaux, but also of their usefulness in the interpretation of an international convention. But again, we shall come to that. My lords, given the very short time that we have, and it really is short, we have prepared a short handout which sets out in simple and direct terms our answers to the questions which the bench had for my learned friend Mr. Ballard during his submissions. Now, to reassure my learned friend Mr. Harris, this is in fact meant to assist the court and himself, because it would have been open to us to simply give these answers orally now, but we thought it would be more helpful to put them down on paper in a way which can be easily probed by the court and which my learned friend can use in reply should he wish to do so. And the document also sets out the structure of the remainder of our oral argument. So if I may hand that out. And what I will do, my lords,
finding difficulty hearing you actually, I'm afraid, Mr. Mooney, with that fan on. I don't know if it's going to be completely unbearable. Turn it off.
We'll turn it down,
We'll turn it down. Let's try turning
If
it down.
it's difficult, I want to have enough.
The difficulty is because
Yes.
Mr. Moreland is right over there and the
I'll turn
fan's
it
just
off.
here.
Turn it
It's,
off.
I'm afraid I
Yeah,
really am
it's a-
struggling. I will hear the fan much more than I can hear you.
And so I'll aim to project your way.
So one of the things about this court, when it isn't boiling hot, is that there are sort of acoustic blind spots, and either end can sometimes be a bit tricky. So if you can try and sort of project yourself into the middle of the court.
Yes,
that'd
my
be
lord, I
great.
actually will move the lectern this way and hopefully
Thank you.
that will help a bit. And if at any stage you cannot hear my lord or Justice Phillips, please
Right.
do let me know. Now, what I intend to do is briefly go through this handout. I'm sure it will prompt many questions. What I will invite your lordship to do is perhaps to bear with me and not ask those questions now, but allow me to develop my submissions, and then we will explore our answers. The first question we answered, you will see, my lord, is the relevance of Mikula, which is a question raised by my lord Justice Phillips on day 1. And we say this, that Mikula says nothing about the issue before the court, which is whether Article 54.1 of the ICSID Convention constitutes a submission to the jurisdiction, and thus a waiver of state immunity. A relevant exception to the general Section 1 immunity in that case was very obviously established. Presence in the face of the court. Romania took a step in the proceedings that falls under Section 2.3b. It wasn't simply forgotten or disregarded by the Supreme Court. There isn't a single reference in Mikula to the SIA. The few references by the Supreme Court to state immunity are rather ironically to the travaux of the Convention, where the Supreme Court expressly recognized at paragraph 71 in his report on the regional consultative meetings, Mr. Brockes referred to certain comments that had dealt with the effect of what was then draft Section 15, which became Article 54.1, on existing law with respect to sovereign immunity. Mr. Brockes explained that the drafters had no intention to change that law. Well, let's just pause there. This is in the judgment they rely on as being perhaps the end, be all and end all of this case. And that is saying that with respect not to 54.3, not to execution, but to adjudication 54.1, Mr. Brockes explained that the drafters had no intention to change the law of state immunity. And you will find that throughout the trouble. Then the Supreme Court also held at paragraph 72 that the trouble showed that the law of state immunity varies from state to state, and the Convention made no attempt to harmonize it. Now, the second question, my lords, is my Lord Justice Phillips concerned that our case and Spain's case would mean that you can never register an award against states, and we say briefly this concern is unfounded over the page. All awards against investors can be enforced, and we do say that was the reason Article 54 was introduced. Because again, you need to bear in mind that duality between the international law plane and the domestic law plane. The states were themselves bound on the international law plane. And Article 54 was introduced to give states a remedy against investors who are not subjects of international law. So that remedy had to be found in domestic law. Prior to the 1978 Act, an award against the state could be enforced in the courts of the losing state or in the UK if the state submitted in the face of the court. Now it said, oh, well, that's fanciful. But that's exactly what Romania did in Mikula. And there are other examples. And when you go through the speech of Lord Gough in Pinochet, he does say that, and it's exactly what you find again in the Travaux and as the basis of the convention, that states will abide, it also means they're expected to be in court if they're faced with a claim. So that's how it was dealt with, by a presumption that they would abide. Other states might have different rules of state immunity. As noted by the Supreme Court in Mikula, the Convention made no attempt to harmonize that. Now, following the passage of the 1978 Act, there is a clear route through in the UK, that is Section 9 of the SIA. And how do you get through that gateway? By showing that there was consent to arbitrate. That is not the position in Australia, and a key reason we do say why the High Court of Australia held that there had to be an implied waiver. Of course, my lords, the seven-judge bench of the High Court of Australia is entitled to the highest respect. Of course. One has to see what they had to decide, the circumstances in which they had to decide it. If I can show you just that one paragraph, paragraph 69, which is in volume A6, tab 89, page 3128. And note, my lords, that this is part of the High Court's interpretation exercise of Articles 53 to 55. Spain's submission requires the text. Paragraph 69.
69, thank you.
Spain's submission requires the text of Articles 53 to 55 to be read in a contorted manner. In light of the effect of the provision in Article 53 that awards shall be binding on contracting states, together with the preservation in Article 55 of immunity from execution only, subject to the laws of contracting states, it would distort the terms of Article 54(1) to require separate conduct that amounted to a waiver of immunity before an award could be recognized and enforced against a foreign state. Now, that's the position in Australia. And because of that counterfactual, the court found that there was what? An implied waiver of state immunity.
And you say that's because there isn't section.
Their section 17, my lord, is narrower than our section 9. You saw it.
But the difficulty with that, isn't it, is that the convention and Article 54 or provisions predated the State Immunity Act. And you have to interpret it as at the date that it was brought into force, don't you? Can't have changed its meaning in 1978.
My lord, I entirely agree. And it was said by Mrs. Justice Dias and by my learned friend Bill when we were arguing the case below. Well, this is just one factor in the Supreme Court, in the High Court of Australia's judgment. It's neither here nor there. As you said, it's not relevant. But what I've just showed you in paragraph 69 is that when interpreting Articles 53, 55, the High Court of Australia is having regard to that fact, which is peculiar to its own system of state immunity. Whether rightly or wrongly, it is not for us to judge, my lord. But that is what we are doing.
But that's the point.
None of that reasoning depends upon the width or narrowness of its arbitration exception. It's all dealing with Article 54, including what you haven't read to us, which is the last sentence of paragraph 69. I mean, that makes it clear what they're saying is Article 54(1) is dealing with adjudicatory immunity, because if it weren't, the effect of Spain's argument would be there'd be even greater immunity in respect of adjudication than there was in respect of execution. That's the point they're making, isn't it?
My lord, the point is that it is a factor which the High Court is taking into account as part of the process of interpretation. I'm not going to put it any higher.
Wasn't that exactly the same position as in this jurisdiction as of pre the Act?
Yes, my lord, and that is the position indeed, and that is actually, we say, a problem for my learned friend's case, because what do they now have to contend? They have to contend that the 1966 Act, which contains absolutely nothing about state immunity, which does not, as I will show you, and that is a very important matter, incorporate Article 54 in English law, did away with state immunity. Because if they don't say that, then there's this sort of, as Mrs. Justice Dias termed it, inchoate period, where it's not going to bind and it's not going to take state immunity away from states. We say this proves that no one, as the Supreme Court said in Mikula, the law of state immunity, our common law of state immunity, was not intended to be changed. There was no inchoate period. That was never intended. During that period, until the UK adopts the doctrine of restrictive sovereign immunity in 1978, there is absolute immunity. It is what it is. There is this sort of subtext, my lord, I'm sorry to have to say it, but that state immunity is some form of cheating. State immunity is a cardinal principle of international law. Has to be given effect to. You can't do away with it tacitly by section 2.1 of an act which doesn't even refer to state immunity, when at that point in time, and that is common ground between my learned friend and myself, there is a doctrine of absolute state immunity. So we say this point works against them. That they now have to contend, and that's why you see, we'll come to that, you now have to see the convolutions, which you've just heard at the end of my learned friend's submissions about section 23.3. You see, with respect, not terribly serious. But if I may be allowed to move on, because I am going to address all these points. The third point we made is very, very important. And this is where this international law, domestic law dichotomy comes into its own. Why is Article 54.1 not an express submission to the jurisdiction? Why is it implied?
If it's not.
Now, the obligation under Article 54.1, which arises at the public international law level, is for what? It's for each contracting state to recognize an award as binding and to enforce the peculiar part of it within its territories as if it were a final judgment of its courts. Now, that obligation means that the UK must create a mechanism for recognition and enforcement in the UK, and that Zimbabwe agrees that the UK must do so. Now the question is this, my lord, does it inevitably follow, because everyone is agreed, at least in this appeal, that that is the test, that Zimbabwe submits to that enforcement jurisdiction? Now it is a possible outcome, we don't say otherwise of the words used, but it is by no means inevitable. Because contrary to what appears to have been assumed in the exchanges on day one, it is not the case that Article 54.1 would be rendered nugatory unless you have submission to the jurisdiction. Article 54.1 operates at the international law level, and it has work to do, whether or not a submission to the enforcement mechanism is implied. It sets out all contracting states' duty owed to each other under international law to create the enforcement mechanism. It has work to do, and that is a fundamental distinction from NML against Argentina, where the agreement to allow enforcement in a number of jurisdictions operated solely within the domestic law plane. And this is why Lord Phillips, and that is why he finds, as he finds, his words are, the provision would be robbed of all effect. And you will remember that NML is really, really the high point of this sort of interpretation of submission. You've seen Lord Collins' separate judgment, and I should point out that Lord Phillips' decision on this is actually obiter dicta, because the ratio is to be found in another part of the judgment. Now, the obligation to create the enforcement mechanism in the present case is the UK's, it's not Zimbabwe's. And it doesn't inevitably follow from one, the fact that the UK is placed under an obligation on the international law plane to create an enforcement mechanism, that too, Zimbabwe has agreed to submit to it. The obligation on the UK exists and bites whether or not Zimbabwe separately agrees to submit. Now, we therefore say, and that's the next bullet point but one, the only way in which a submission can be found in Article 54 is very obviously by means of a process of implication. The provision has work to do whether you find that or not. The only way you can get there is by implication. And you see that there's so much reliance on the other side, my lord, on Schroyer. Let me show you again what Schroyer says in one of his earliest writings on that. If we could please go to A8, tab 123, page 3927. Which is the final page of the article. And I think my learned friend for Spain took you to this. Sorry, A8, 123, tab 123, page 3927. And you see that Professor Schroyer here is considering, sorry, I should say that the article is entitled, you find that in 3912, State Immunity, Some Recent Developments. And Professor Schroyer says, and that is in the left-hand column, the sentence starting about 12 lines down, but a combination. Sorry, starting before the sentence before that. Therefore, the ICSID Convention on its own would not be a valid ground for withdrawing immunity in proceedings, I stress the words, my lord, to enforce an award. We're not talking about the execution of the judgment, but enforcement of the award. The ICSID Convention on its own would not be a valid ground for withdrawing immunity in proceedings to enforce an award, but a combination of what? Accepting submission to arbitration as a waiver of immunity and of the ICSID Convention as providing the necessary jurisdiction linked to the forum state may achieve this result. If, by virtue of a statutory provision containing what? 1, an arbitration exception to immunity, or 2, a waiver clause accepting submission to arbitration as an implicit waiver, immunity is denied in principle in the respective country, then the general obligation contained in the ICSID Convention to enforce awards should overcome any lack of a jurisdictional link to the forum state. Well, these are the two routes. It's clear as day from the one authority that is being cited to you, left, right, and center, saying 1, the ICSID Convention doesn't do it. 2, if you're going to do it by way of a waiver, meaning submission in this jurisdiction, it is implicit. It is not express. So you will need a statutory provision that says you can have an implicit waiver. And 3, which is the normal way to do it, and the way we do it in this country, Section 9, an arbitration exception. My lord, this implied idea you also find, and that I will not take you to because my learned friend Mr. Ballot took you to that, in the US Foreign Sovereign Immunities Act. The doctrine is actually called Doctrine of Implied Waiver. And the Australian High Court aligns itself with the US Doctrine of Implied Waiver. Again, I will not take you to that. You've got the reference here. Now, what is more, as we will demonstrate, the correct interpretation is in fact that states intended no submission or waiver of immunity from adjudication where that immunity existed, which would vary from state to state, as Mikula says. The domestic law mechanism was created to give states a remedy against investors. The remedy against a non-compliant state was what? Something very different, my lords. The revival of diplomatic protection on the international law plane, coupled with the jurisdiction of the ICJ. And if I may take that again, my lord, from the one authority they rely on the most, which is Mikula. Can we please go to Mikula, A4, tab 45. And it would be bundle page 1698. Paragraph 105. The structure of the ICSID Convention supports this interpretation. The Convention establishes the Center to provide facilities for conciliation and arbitration of investment disputes between contracting states and national subcontracting states. The Convention provides that in relation to such disputes, etc., the obligations of contracting states, and I'm reading from 6 lines down, next 2 sentences after that, the obligations of contracting states in Articles 53, 54, and 69 are expressed in unqualified terms without limit as to the persons to whom they are owed. Article 64 is expressed in entirely general terms, which are apt to include disputes regarding the obligations set out in those articles. And that is the article that contains a reference to the International Court of Justice. These features of the convention regime provide a strong indication that a contracting state which has obligations under the convention in relation to an award owes those obligations to all other state parties to the convention as well as to any party to the award. Article 27.1 confirms that the obligation on a contracting state against whom an arbitration award is made to comply with the award is not just owed to the other parties to the dispute, since it recognizes that any contracting state whose national is involved in the dispute may bring an international claim against the other contracting state if it fails to comply with the award rendered. And then it cites Professor Schroyer, and final sentence, the same is true of the obligation under Article 54, as Professor Schroyer confirms in his commentary on that provision at page 1125. So, my lords, that is the consequence. My lord.
Just trying to understand where this takes you. I mean, there's a reference in relation to Article 27 confirming that a recognition that a contracting state whose national is involved in a dispute can bring an international claim. But that's a claim by the state. So what's the investor supposed to do?
The investor, my lord, so what is being said on the other side is that it must be assumed, but again, assumed that what was intended is that the investor was being given this domestic law remedy and therefore state immunity would go. And we say, in fact, and this is what this is showing you, what was being contemplated, and I will show this to you, the negotiators were proceeding on the basis that states would be expected to comply, and that if there wasn't this dual domestic plane, international plane dichotomy, there would be no need for a domestic mechanism because of this. You see, the ICSID Convention was revolutionary in the sense of doing away with diplomatic protection. It was felt that what was happening is that every dispute was being politicized, gunboat diplomacy. Whenever a national was being, or his assets rather, were being mistreated in a country, it would run to its home state and try and raise it to the diplomatic level. So the whole idea was to diffuse that situation and therefore do away with diplomatic protection, which is what Article 27 does in the first place. But it does say, but if you're not complying, diplomatic protection is being revived. That is the sanction, and that is taking place at the international law plane.
I mean, you're obviously going to develop that argument. I don't really see that paragraph 105 helps you.
Well, my lord, so be it. What I wanted to show you is that Mikula recognizes this regime enforceable, which is not always the case, of course, for public international law obligations, between the contracting states of what is to happen when you have a non-compliant state. Let's leave it at that, perhaps, for now, my lord. Now, our penultimate point on this was the High Court of Australia wrong? And the question about the potential for fragmentation among different domestic jurisdictions. Questions from both my Lord Justice Phillips and my Lord Justice Newey. Well, as noted by the Supreme Court in Mikula, again, the Convention made no attempt to harmonize the law of state immunity. That will vary from state to state, and it is natural that there will be different outcomes and reasonings in different jurisdictions. For instance, the French courts have not even analyzed Article 54. And all my learned friends for the investors make a lot of fun of poor Mr. Justice Walbank in Tetian, which says something which is absolutely right in our respectful submission. And the fact that he says it pithily doesn't make it wrong, because you're always being taken to this judgment, and they open the page, they have a laugh, and they close it. But what he says is actually right, but leave that aside. Let us look at the reasoning of the French courts in the judgment that recognizes no immunity from adjudication in French proceedings. That's Soabi, and you will find that at A6, tab 80, page 2908. I don't have much time, but if I can take you straight to the relevant passage, which is sideline on 2908. And see the reasoning here is whereas, however, a foreign state which has, and I stress the words, consented to arbitration. So again, they are looking at consent, has thereby agreed that the award may be granted recognition ex equatur, which as such does not constitute a measure of execution that might raise issues pertaining to the immunity from execution of the state concerned. And then, over the page, whereas the Convention of Washington, the ICSID Convention, has instituted in its Article 53 and 54 an autonomous and simple system of recognition and enforcement, which excludes the system provided for in their Code de Procédure Civile. So, what is this doing, my lords? First, France is a monostate, so the convention has direct effect, which is not the case in this jurisdiction. And I stress again, because no one, and with respect, I find that extraordinary. We're now on day 4 of this hearing. No one has actually highlighted that the convention is not part of English law. And I will show that to you. Very few provisions have been enacted into English law, transposed, not others. In France, you've got a monostate, and then the ratio of this decision is that the foreign state has consented to arbitration. And I will show you something which will explain that to you, and I think also places an important perspective between the distinction between civil law jurisdictions and common law jurisdictions when we come to this distinction between immunity from adjudication and immunity from execution. And you'll remember, there's a never-ending debate about the meaning of those words. And the High Court of Appeal says one thing, you should note that Professor Schroyer says the opposite. And I think that maybe that article by Delhomme, which actually Professor Schroyer refers to regularly in his writings, will give you an understanding of that. So if we could please look at that. A9.
Are you leaving the French case?
I am indeed.
Just, forgive me.
Just bear with me.
I'm afraid I just haven't understood what you're saying the significance of it is. I may be being very slow.
Say again, sorry, my lord.
I'm sorry, I haven't understood. I'm afraid I haven't understood what you are saying is the significance of the French case.
So this is on the point that every jurisdiction will have its own rules of state immunity and its own regimes, and you cannot. So one very basic point, I'm sorry, which I should have made, is that there is no interpretation of Article 53 and 54 whatsoever here. And that is the decision which the French courts have relied on since to find that ICSID Article 53, 54 constitutes a waiver of immunity. So if there's going to be criticism of Mr. Justice Wallbank, then this is even less helpful. What you see is that the ratio of this is one that France being a monostate, they say, and that's the passage on 2909, Articles 53, 54 have replaced the Code de Procédure Civile in those matters. And on the previous page, that they find that the consent to arbitration, the foreign state which has consented to arbitration has thereby agreed that the award may be granted recognition. So they say state immunity from adjudication has been done away with because there's been consent to arbitration. And that's what I'm now trying to explain to you, that second point, my lord, by reference to the Delhomme article.
And in this case, the consent to arbitration was by what mechanism?
My lord, I would need to check. In Benvenuti, I know it was a contract. In all these early ICSID cases, it tended to be contract cases. So
This decision, I mean, it's a typical decision of the Court of Cassation with respect. I mean, it's 30 odd years ago. It's pretty limited reasoning, but as I read it, it's expressly saying that the award is enforceable against the state of Senegal under Article 54 of the Convention.
with no analysis with respect, my lord, and I will show you
I
again.
don't mind the no analysis, because that's just typical of the Court of Cassation.
Yes,
It is authority of the highest French court, the proposition that Senegal could not rely upon state immunity for the purposes of execution.
My lord, again, this is all in the context of different courts applying different rules. And I think, with respect, my lord, I think you're making my point, that the French rules are rather different. And if I can show that to you by reference to the article by Delhomme, which is at A9, tab 165, at page 4860. A9, tab 165.
That's it.
This is, if you go to 4830, you will see this is an article on state contracts and
We haven't got that.
transnational arbitration by the law.
We haven't got TAC 165.
I did ask my solicitors 3 times, twice yesterday and again at 6 AM this morning to make sure they were in.
Is it in the updates? Is it, we've got a separate, yes, it's we've got.
Oh, I see.
We've got a separate file with.
I see. I
separate
apologize,
file.
my lord. So whenever I refer to something like that, I will
Right,
let you
it's a
know.
separate file. Right, okay.
It was supposed to be inserted in
Put
A9.
line away and look at a separate file.
Please forgive me, my lord. I'm mistaken as to where it should be. So it is tab 165, wherever you have it.
Okay.
The article itself is entitled State Contracts and Transnational Arbitration by Georges Delhomme, who was then a senior legal advisor at the
The
IBRD.
date of this is what?
(1981).
Right.
And then you have a section which starts at 4860 on ICSID awards. And then at 4861, you have the impact of sovereign immunity. A threshold question. Whether an award can be enforced by execution against a state and its property is an issue that must be decided in accordance with the sovereign immunity rules obtaining in the forum in which execution is sought. However, before measures of execution are considered, a preliminary question must be solved. Execution proper can ensue only after recognition of the award in the form of a confirmation and exequatur or similar proceedings. The nature of these proceedings is still a matter of controversy in the sense that they may be regarded as the ultimate phase of the arbitration process or as the preliminary phase of execution. And then he goes on to explain, and I will show that to you, my lords, that in France they take the latter view, but not in this jurisdiction. We've never considered that exequatur proceedings are part of the arbitral process. So he said, understandably, states usually contend that the second characterization should prevail. As a rule, however, this argument has failed to impress the courts where? In the Netherlands, in the US, and in France, which have held that when a state has waived its immunity by submitting to arbitration, the scope of that waiver extends to proceedings for the confirmation or recognition of the resulting award. And then he expresses his view that that's how it ought to be, etc. Why do I show this to you? Again, to show the very different regimes. And I respectfully submit that explains to you why we have these difficulties across jurisdictions and
Well,
across languages.
With respect, those two paragraphs are completely against you, because I mean, he's making the point there. If one's looking at recognition and enforcement in the terms of Article 54, then if the arbitration is won against the state, that's what the arbitration is being referred to, then state immunity shouldn't be capable of being relied upon, because it would make a mockery of the arbitration process.
In France, my lord.
Of course,
and
we're
in
only
France,
looking at France
but-
in this instance.
Yes, my lord, but
Before you, I thought you were trying to demonstrate that in France the position was different than it is in this jurisdiction.
what I'm demonstrating is that there was no attempt to harmonize the law of state immunity, and it will vary from state to state.
Well, it's an
and-
example of both the decision of the Court of Cassation and this article, an example of French judges and lawyers saying state immunity shouldn't arise in relation to recognition and enforcement.
Because it is not an issue, my lord, with respect in France. There's no state immunity from adjudication in the way in which we understand it in this country. Because they hold that the consent to arbitrate brings with it the right to exequatur. Immunity only kicks in at execution. This, my lord, is why you have this debate in the various languages about execution enforcement, because civil law differs from common law.
Because of
We do
exequatur.
not have this regime. We have immunity from adjudication.
Because of the doctrine of exequatur. And I think there's some reference somewhere in one of the English authorities, I forget which one it is now, to the fact that it is different under civil law because there is where we would recognise distinctions, they don't.
The High Court of Australia says that,
Yes,
my lord,
the
is
High
maybe
Court of
where
Australia.
you read it. And I think, to come back to my point, that does show that all these cases and the various jurisdictions treat the matter very differently, and you cannot just make assumptions. Cannot. Point 5 is just a simple, straight answer to the question asked by Lord Justice Newey, I think. Would a treaty clause saying all contracting states submit unequivocally to the jurisdiction of the domestic courts of each other state, or the contracting states will submit to the recognition of awards, be sufficient? Yes, we say yes, but that is not what Article 51 does. Then on the, maybe you can keep this by your side, this little roadmap, because that's the roadmap of our submissions. And just so you know how we are actually going to divide our time, because we heed the advice that juniors should be given time, even in the Court of Appeal or Supreme Court. So my learned friend, Mr. Tompkins, will address you on section 9, which is the last section of this structure.
Okay, right.
Now, with this, I turn to my 5 preliminary points. And we address those up front, my lords, because we do not wish for you to have any doubt as to the answer to these points as you then hear the submissions as we go through the legislation. The first point, my lords, is the importance of the point which is being decided by this court. Your lordship should be in no doubt about the novelty and importance of the point which it falls to you to decide on this appeal. State immunity is a cardinal principle of English law, which gives effect to public international law obligations of the United Kingdom, which are no less important, and one may forcefully argue, more important in terms of committee and international legal order than the United Kingdom's obligations under the ICSID Convention, such as they are. Zimbabwe, like all foreign states, has presumptive immunity before this court, section 1.1 of the State Immunity Act. The ICSID Convention is 60 years old, yet the drive to argue that it has tacitly done away with immunity from adjudication in this jurisdiction and in other Commonwealth jurisdictions is a couple of years old. Before then, and think about that, my lords, in a 60-year-old convention, before then, no one sought to circumvent state immunity in this way in any Commonwealth jurisdiction.
We've got statistics as to whether state immunity was ever raised.
My lord,
Nobody thought to raise it because no state had ever raised it against the investor.
Well, I'm sorry, but that is just an assumption.
I'm asking the question.
Well,
have you got statistics
this
to show how many times an ICSID award has been made against a state where the state has raised state immunity as a defence and that's been accepted by the relevant enforcing court?
What we have, my lord, are reported cases, and we know that this point hasn't been taken other than 2 years ago.
But is that likely to be because the EU issue arose and therefore there seemed to be room for dispute about section 9?
Well, no, it's not. The section 9 point arises in every or most arbitration because it's simply a question of jurisdiction.
But would it until recently have been assumed that one way or another, section 2 or section 9, the state was bound?
No, my lord. There's one article which my learned friends have put in the bundle, which is from one of my fellow editors on Arbitration International, Andrea Bjorklund, which actually already 12 years ago discusses the massive problems that there are with enforcement against states. And she sees it from the perspective of we need to make the system work. And Working Group 3 at the moment is grappling with all these issues. This has become an absolute minefield, the field of investment arbitration. States are not complying. States are leaving the ICSID Convention. States are leaving BITs. That is the reality of the battlefront of
Well,
what we
that's
do.
all very interesting, but your clients haven't sought to leave ICSID, have they?
No, my lord. I think we're being sidetracked. I was trying to answer your question.
No, I'm sorry to press you on it, but you. I mean, it's the point that my lord made. I mean, like my lord, I rather suspect that all this sort of furore, if I can put it that way, about the with the EU may have led to other states, non-EU states, jumping onto a bandwagon, if I can put it that way, which hadn't previously been focused on.
My lord, with respect, that is not the case. The problems predate the EU issue of which
Well,
is
go back to my question then. Other than the ones we've got in the bundle, are there any cases decided in any other jurisdictions where a state successfully resisted enforcement of a recognition and enforcement of an ICSID award against it by relying on its domestic law of state immunity?
Well, again, in the Commonwealth jurisdictions, it's only
No.
in the past couple of years that this point
Anywhere
has
else?
resulted in
Well, French decision.
yes, my lord. But again, I say there is a distinction of principle between how state immunity is viewed because of executor in civil law jurisdictions and in Commonwealth jurisdictions.
I mean, I do follow that, but in terms of results, as I understand it from, say, your page 4, actually courts in France, America, Australia, New Zealand have all said there's no immunity.
Because again, my lord, the law of state immunity is what it is, not because intrinsically that must follow from Article 54. That's my simple point. That's it, all I'm saying to you, that you must analyze. Because there is a huge push from the other side saying, well, everyone's decided, why should you bother? Not at all. We've got our own state immunity legislation. We've got our own way in which we have transposed the convention into our law. One must analyze. You cannot avoid that analysis.
I don't think there's any suggestion that we're not analysing.
I'm grateful, though.
I think though, the one respect in which we can is in relation to the High Court of Australia decision, which is another highly respected common law court, which was considering identically worded state immunity legislation. And that is highly pertinent in this jurisdiction.
My lord, with respect, it is not identically worded because they have this lacuna in respect of Section 17,
Well,
which again they
forgive me,
find
you know what I mean.
relevant.
The relevant section dealing with submission to the jurisdiction is identically worded.
The simple answer, my lord, to the High Court of Australia decision is this: that whichever way you want to look at it, they end up following the implied waiver approach of the United States. And they may say it's entirely open to them, of course, as the highest court of Australia, to develop their law in that way. It is not open to this court. And if it goes higher, we'll submit that Pinochet should continue to be good law in the UK for good reason, because it is consistent with international law. Simple answer on the High Court of Australia. I'm not criticizing it at all. They're entitled to develop their law as they wish. I'm just pointing out to you, it's very clear why they did it. Because otherwise, there would not be ever enforcement of an ICSID award against a state in Australia. They had to do it. Everyone seems to say it's irrelevant. I don't think it is. I think it's very relevant. I think that's why they pushed that way. But anyway, as a matter of law, they went implied waiver. You cannot go implied waiver. That is our respectful submission.
Well, forgive me, but was this implied waiver? It's certainly the analysis there, but what they actually decide, don't they, is that there was submission.
Well, submission, I will come to that when we come to the relevant test under Section 2. But it's never been suggested, and I think it is common ground, and my learned friend was doing his best to tell you it is common ground, that the test under Section 2 is consistent with the international law test. You cannot have an implied waiver under English law. That's very, very clear under Section 2. You must have an express waiver. The battleground between us is simply whether the words are such that it is to be considered an express waiver or whether it is an implied waiver. If you were to hold that this is an implied waiver, you would be acting contrary to Supreme Court authority. And we say it's implied for the reasons I told you from the document that we've given you, which is it's not inevitable. It's something that could happen, and the big difference with NML is that in NML, if the words are not construed in this way, they are meaningless, they are otiose. In the treaty, of course they operate. Simple question is, does it follow from the fact that you are under an international law obligation to create an enforcement mechanism, that all other states that have contracted with you have agreed to submit to that enforcement mechanism. I think the question only needs to be asked for the answer to be get. Maybe, maybe not. That's the end of their case. It is not inevitable. My lord, I was going to say that because of the importance of the issues you have to decide, it's crucial that we all apply a degree of added rigor. And it's crucial, for instance, to ensure that the treaty at issue here is interpreted and is seen to be interpreted in accordance with the VCLT and with settled principles of public international law. In short, a treaty is not a commercial contract. Particular care must be taken when analyzing the material. To take a very prominent example, it is not the position that Article 54.1 of the ICSID Convention was modelled on Article 192 of the Treaty of Rome. This is just incorrect. Well, Article 192 of the Treaty of Rome was referred to and became the model for Article 54.3. Article 54.1 was modelled on what? On Article 3 of the New York Convention. And that was from the very outset of the negotiations. If you can please look just at two passages in volume A9, tab 155, page 4529. This is the very first draft, the working draft of what becomes the convention. You see here Article 8 at the top of internal page 26, recognition of arbitral awards by contracting states. Here will be inserted a provision substantially to the effect that contracting states will give to awards rendered pursuant to the convention the most favorable treatment they give to foreign arbitral awards, whether under their internal law or pursuant to the Geneva Convention of 1927 on the execution of foreign arbitral awards, which you will all be familiar with, which has the requirement of double exequatur, or the United Nations Convention of 1958 on the recognition and enforcement of foreign arbitral awards, also known as the New York Convention. You then find the draft. This becomes section 15, and you find that at page 45, maybe start at 4542. By then, you've got a first preliminary draft at 4542. And if you turn the page to 4544, you've got section 15. And just above it, if I can draw your attention also to section 14, which becomes Article 53. And you will note, Lords, that at that point in time, there was no Article 54.3 and no distinction at all between adjudication and execution. One provision, which is about enforcing the award. And then if you turn, please, to 574, internal, which is, sorry, 4600 in the bundle.
4600.
4600. And we're now at the stage of discussion of this section. At paragraph 74, so enforcement of the award, section 15, Article 4, section 14, which is the equivalent of Article 53, of the working paper provides that the award shall be final and binding on the parties and that each party shall abide by the award and comply with it. If the convention had dealt with disputes between states, no further provision on enforceability of the award would have been necessary, since the parties to a dispute would be directly bound by the convention and could be expected to comply with their obligations thereunder. In any event, the relationships established would be entirely in the sphere of public international law. However, the proposed convention deals with disputes between states or state agencies on the one hand and investors on the other. It was therefore felt essential to include in the working paper a provision regarding the binding force and enforceability of awards in the municipal sphere. Such a provision would moreover be justified as establishing equality, not only of rights but also of obligations between states and investors. If a state lost an arbitral proceeding, it was under direct international obligation to comply with the decision. If a state won in a proceeding against an investor, it should be able to secure compliance by the investor who was not a party to the convention. Section 15 seeks to achieve the objective outlined in the previous paragraph, and it says what it provides. A first group of comments was addressed to the question whether the provisions, etc., and that is where you see the reference to Article 192 of the Treaty of Rome. So the provision is modeled on the New York Convention, and then what becomes Article 54.3 later is modeled on Article 192. If I may pick it up, please, at paragraph 77, some delegations express concern about the legal and political effects of the enforcement provisions on the position of third states, i.e. states which neither directly nor through their nationals had any connection with the dispute. They wondered why any obligations should be imposed on such states in connection with awards rendered regarding disputes to which they were strangers. I replied that recognition of awards in third states was not basically new, since it was already provided for in the Geneva and New York Conventions on the recognition of foreign arbitral awards. The working paper admittedly went further than those conventions by excluding a number of grounds of attack on the award permitted under the earlier conventions. But, and that is very important when you hear all these points about scheme, this was a difference of degree rather than of kind. So the grounds of review are being limited, but that is a difference of degree rather than of kind. 78, a third group of comments dealt with the effect of Section 15 on existing law with respect to sovereign immunity. Bear in mind, my lords, at this point in time, there is no 54.3. There is no question of execution of a judgment. This is about enforcement of the award. I explained, and that is Mr. Brockis, that the drafters had no intention to change that law. By providing that the award could be enforced available by a final judgment of a local court, Section 15 implicitly imported the limitation on enforcement which in most countries existed with respect to enforcement of court decisions against sovereigns. However, this point might be made explicit in order to allay the fears expressed by several delegations. One delegation felt that consent to submit a dispute to arbitration should carry with it a waiver of sovereign immunity with respect to enforcement, and I emphasize the words of the award. But my point, I think it was important to show you the whole passage because I didn't want to come back to it, my lord. But my simple point at this stage is that the submission that was made to you by my learned friend for ICSID is incorrect in that the model for Article 54.1 is not Article 192 of the Treaty of Rome, but Article 3 of the New York Convention. Madam, I'm going to try and take the other, I'm really doing very badly for time, I must say. So I can skip, I think, point 2, which is the invitation to shirk analysis. But, as for Mikula setting no binding precedent, I think you've got my point, my lord, which is in the roadmap. The one thing I wanted to show you, because what is that Mikula is saying there's a scheme to the convention which internalizes grounds of review, and therefore it must follow that state immunity is also done away with. And what I want to show you is an equivalent decision of the Supreme Court under the New York Convention. So remember, Mikula is about stays, and this is about orders for security. And this is the decision of IPCO Nigeria. And you will find there that the Supreme Court says the same thing, which is the New York Convention is a complete code. It is its code. That says nothing at all about state immunity. If I may take you there, the decision is at, well, it should be in your supplemental bundle, I guess, because it's my tab 166. It should be in your new bundle at tab 166.
Yes. Yeah.
Right. The issue was whether the English court could make an order for security, this was a New York Convention case, for all or part of the award, because there were challenges to enforcement, outside the conditions laid down for the grant of such security in Article 6 of the New York Convention. And you can find that at page 4874 in Lord Mence's speech, paragraphs 15 and 16. Perhaps if you can just glance at that, my lords, you will see that was the issue. If you turn to paragraph 41, at page 4881, see that Lord Mence says pretty much what the Supreme Court ends up saying in Mikula. In my opinion, the conditions for recognition and enforcement set out in Articles 5 and 6 of the Convention do constitute a code. So in Mikula it was stays, here it's orders for security. You abide by the code of the Convention. No, that says nothing at all about state immunity. Perhaps the final point I will cover before lunch, and I think that will be the last preliminary point. I won't cover point 5, which I think you have, which is the conflation, which we say is being made on the other side between 1, avenues of challenge, grounds of review, and 2, state immunity. As I just showed you, they are separate.
Could I just ask you before you move away from
yes, no.
Is that certainly Mr. Justice Fraser placed a great deal of weight on Mikula and effectively regarded as binding on him. I didn't understand that that was the basis upon which much of the argument was being put for the investors before us.
Good.
So,
My lord, I'm grateful. Then we can move on.
Well, I think that's right. I mean, I think it's accepted that we've been taken to a few paragraphs in it. It's accepted that the issue of state immunity wasn't being dealt with in Mikula. So it's only of marginal relevance, really.
That is helpful, because that is the way in which the case was being run before.
We can cut that, I think.
Thank you, my lord. Now, the point 4, A4 on the outline rule is this, that the investors submit that key authorities, in particular Tatneft, which were taken to very briefly, and the seminal case of Dala, which stands for the very basic proposition that competence doesn't mean that tribunals can pull themselves by their own bootstraps. Another doesn't seem to like the idea, but it's not my terminology. It's Lord Collins, I think, or Lord Mence's. But these demonstrate the logical fallacies of their approach under Section 9, but they're telling you those can be ignored because those decisions concern the New York Convention. And we say with respect, this is misconceived. The State Immunity Act, which was enacted after the accession of the UK to both the New York Convention and the ICSID Convention, applies equally to proceedings brought in this jurisdiction, pursuant to the enacting legislation of each convention. The 1966 Act, then the 79 Act, I think, which implemented the New York Convention, and now, of course, we've got the 96 Act, and the issue's gone away because it's subsequent legislation. But the 1966 Act, and the point has been made, but I think it really bears repeating, is not excluded under Section 16 of the SIA. All those convolutions around Section 23 with respect are quite extraordinary. If the legislator wanted to exclude the 66 Act, it had itself put a mechanism in the Act, that's Section 16, they would have put it there. The provision which is said to constitute a waiver of jurisdiction under the ICSID Convention, Article 54.1, is in near identical terms to Article 3 of the New York Convention, and I do stress that the law in this country is that has never been held. Article 3 of the New York Convention has never been held in this jurisdiction to constitute a waiver of state immunity from adjudication. And but as you can see, I won't do it now, I'm really doing badly for time, but we have juxtaposed, you can make a note please, we have juxtaposed Article 3 and Article 54.1 and paragraph 46, paragraph 46 of our supplementary skeleton. They are identical, save for this question of procedure under the domestic rules of procedure. And I will address that point when we go there. And that's no coincidence, because Article 54.1 was modelled on Article 3. So the correct approach is accordingly to analyse the differences and similarities between the two conventions and their enacting legislation, and I intend to do that after lunch. Okay. I would just draw your attention, my lords, still on this point. On footnote 28, at first instance of my learned friend's skeleton, because I'm sorry to say I think they have now resiled from that, but it's very important because it shows the breadth of the submission. You will find that in that supplemental, not the Spanish one, the Zimbabwean one, the supplemental bundle.
Let's just find that.
And it's at page 229 of that bundle.
229.
229.
Thank you.
And it's footnote 28. In respect of state immunity, the better view might be that not just the ICSID Convention, but also the New York Convention gives rise to an express waiver to immunity from adjudication. This was the recent finding of the Federal Court of Australia in CCDM, and it follows the approach in the United States. Zimbabwe says that this cannot be right in England because of the decision in TAPNEF, but the claimant in TAPNEF only relied on Section 9. And we say this shows the breadth of their submission. Once one starts to accept, as the Australian courts have done, that Article 54.1 constitutes an implied waiver, one is inexorably drawn to the same conclusion in relation to Article 3 of the New York Convention. And that, and we adopt with respect the words of Mrs. Justice Dias, would represent a complete sea change in English arbitration law. And that's recognized at paragraph 20, 21 of Her Ladyship's judgment.
Has the, sorry to ask a similar question, Mr. Muller, but has the issue of state immunity arisen in the context of enforcement of has the issue of Section 3 or whatever?
Section 2. Oh, sorry,
Part
of Article 3. Of Article 3.
Article 3 of the New York Convention, and whether or not it constitutes an agreement to waive state immunity actually being raised in this jurisdiction. It's not been raised in Australia.
It's now been raised in Australia. Why has it been raised?
But has it been raised in this jurisdiction? I don't think it has. It doesn't sort of ring any bells.
My lord, if I may answer your question. It is now being raised. Since the decision of Mr. Justice Fraser, everyone is jumping on that new bandwagon.
Oh, okay. So that decision in Australia is the decision of Mr. Justice Jackman, is it?
Yes, which follows, and you can see exactly why the ground is now taken, even though they do have an arbitration exception for New York Convention matters, commercial matters, in their Section 17. So we say this shows you that this is clearly not the way to go.
Why is that? Why does it show us it's not the way to go?
But because this would mean, my lord, that the arbitration exception, and for many reasons, but as Mrs. Justice Dias has said, it would represent a sea change in the way we have approached the arbitration exception. We've always approached this on the basis that it is for us, for the courts in this jurisdiction, to check and confirm consent to arbitrate. Because it is being said, oh, you're being completely unreasonable. But all that is being said is this: you must check consent to arbitrate. This is what TAPNEF says. This is what the commercial court has been doing day in, day out for all foreign arbitral awards. And this would now go away in one fell swoop. Section 9 and the amendment moved by the Solicitor General would effectively have been done for nothing. Because all foreign arbitral awards would now fall under Section 2, except for minority. And I've never seen, my lord, I must tell you, I've never seen a foreign arbitral award being enforced at common law as opposed to under one of the conventions. So Section 9 and the amendment that is meant for it to apply 2 foreign arbitral awards was that there was no purpose for it. We do say this is a sea change. Not our words. This is Mrs. Justice Dias's word. And this is why we say my learned friend is now running away from what he said. This is why I need to go back to his first instance skeleton to show you the breadth of his submission. We say that the correct analysis under both conventions is under Section 9 of the State Immunity Act, which requires the court to decide for itself whether the state has consented to arbitration. Well, it is now 1:01. I'm very loath to ask, and please say no, but might it be possible to resume at 1:45?
Oh.
I would completely understand if it's not.
Well, you know, this is the trouble. I have a lot of other things I have
Yes.
to deal with. If you'd said to me at 10, somebody said to me at 10 o'clock, we want to sit at 1:45, I might have been able to do something about it.
My
but I
lord,
can't.
forget it. Leave
And
it.
you all had a lot of warning from the court from day one that you needed to get your timetables in order as to how much time you needed. True it is that we have all intervened to some extent, Lord Justice Newey less than the rest of us, but the fact is there's a limit. Really.
My lord, I take the criticism. I would.
Starting at 10 and then expecting
Yes.
us to cut short to 1:45 is not good enough, I'm afraid.
My lord, if I may, I would just say that in my defence that I'm
not
coming
criticising you.
after 3.
I'm not criticising you
I'm
in the
grateful.
slightest, because you've
I'm
got to have the opportunity to make your submissions.
Thank you.
But the answer to your question, should we sit at 1:45, is no. We'll sit at 2 o'clock. And if we run into difficulties, we'll just have to see where we go. Right, thank you.
Court rise if able.
We're making some.